Aloha mai kako, good morning. This is the December 30th, 2020 Land Use Commission meeting and is being held using interactive conference technology linking video conference participants and other interested individuals of the public via the Zoom internet conferencing program. We're doing this in order to comply with state and county official operational directives during the COVID-19 pandemic. Members of the public are viewing the meeting via the Zoom webinar platform. For all meeting participants, I would like to stress to everyone the importance of speaking slowly, clearly, and directly into your microphone. Before speaking, please state your name and identify yourself for the record. Also, please be aware that all meeting participants are being recorded on the digital record of the Zoom meeting. Your continued participation is your implied consent to be part of the public record of this event. If you do not wish to be part of the public record, you should exit the meeting now. The Zoom conferencing technology allows the parties and each participating commissioner individual remote access to the meeting proceedings via our personal digital devices. So also please note that due to matters entirely outside our control, occasional disruptions to connectivity may occur for one or more members of the meeting at any given time. If such disruptions occur, please let us know and be patient as we try to restore the audiovisual signals to effectively conduct business during the pandemic. In that regard, if you're attending a meeting via phone as an attendee, you can use the *9 key sequence, *9, to virtually raise your hand if you're having connectivity issues. My name is Jonathan Lee K.K. Scheuer. I am currently serving as the LUC chair. Along with me, Commissioners Axon. Oh, Commissioner Axon is absent today. Commissioner Chang, Okuda, and Wong, our LUC Executive Director, Daniel Ordenker, our Chief Planner, Scott Derrickson, our Chief Clerk, Riley Hakoda, and our LUC Deputy Attorney General, Dan Morris, as well as our court reporter, Jean McManus, are all on the island of Oahu. Commissioner Cabral is on Hawaii Island. Commissioner Lee Ohigashi is on Maui, and Commissioner Giovanni is on Kauai. We currently have 8 seated commissioners of a possible 9. Now, as is appropriate for a meeting on the last day of the end of a tumultuous year, we have some transitions. I'm going to ask Dan Ordenker to make a couple of announcements in that regard.
Thank you, Mr. Chair. First of all, I'd like to thank everybody for a very difficult year and for the commissioners' hard work in getting us through the year and to this point. As you all may be aware, we have been involved in a long, arduous search for just the right person to assist us in both our administrative functions and in some of our more substantive functions. And after much work and effort, we have finally found Natasha Canones, who I'd like to introduce to you right now. She will be taking on both a lot of our administrative functions, quote unquote Ariana's functions, as well as transitioning into doing a lot of Riley's work so we can remove some of the workload from Riley and he doesn't collapse on us. But also like to, and please, if you get a phone call from Natasha, you know who she is, and we hope you all enjoy working with her. Please call on her for any of the administrative problems that you may have had in the past that you addressed to either Riley or to Ariana. Also, after 30 long years at the state, our Planner 5, Bert Sorowatari, is retiring. And we'd like to thank him for his tremendous service, his good work, and his assistance in keeping the Land Use Commission historically sound for over 30 years. And we're going to miss him. And we really appreciate everything he's done for us. Natasha has a lei for him.
Did any of the commissioners wish to say something regarding Bert? You can at the end of the meeting as well. Oh, Commissioner Okuda.
I can wait until the end of the meeting if you want.
Okay, no, please go ahead.
Yeah, Bert, I'd like to thank you for your work. A lot of negative things sometimes are said in the community about, and I put this in quotes, state workers. But what I found, not only with you, but the other staff members at the Land Use Commission are truly dedicated servants to the community who do and continue to do and have done tremendous work in upholding the obligations which the Constitution has imposed on the commission and the government, and also what the community expects. So, Bert, thank you very much for your work. Thank you for your service to the community, and thank you for all the things you personally done for me while I've been on the commission. Thank you, Mr. Chair.
Thank you. We can have time at the end, but is there anybody else who wanted to say anything at this time?
Yeah.
Commissioner Chang.
Thank you, Chair. Yeah, no, I like Commissioner Okuda, Bert, really greatly appreciate all of your diligent work. I've advised a lot of boards and commissions in the past, but the Land Use Commission is probably one of the best run commissions in the state. And that is really due to the hard work of the staff in preparing the commission to take on some of these really major issues that come before us. So thank you so much, Bert. Enjoy your retirement. We will miss you, but I'm sure you are going to be doing well. So take care. Thank you again. Thank you, Mr. Chair.
Thank you. Commissioner Ohigashi.
Bert, I'm the newest member on the Land Use Commission since nobody has been appointed to take over Aaron Mahi's, but I appreciate your work. What more I appreciate is the fact that you still have black hair. I don't know if that's artificial or not, but you still have black hair compared to the rest of us. That gives me hope that my short time on the commission will not result in additional whitening. Which anyway, Bert, I really appreciate you. Thanks a lot.
Yeah. Commissioners, I don't want to cut anyone off. I'll just add, I've personally benefited tremendously, Bert, from your vast experience and your really deep intelligence on these matters and how to apply the law. And I always knew I was treading on slightly thin ground. There was just always a slight eyebrow raise that when I would be saying something and be like, okay, Bert is not sure where Jonathan's going on this. I've appreciated your kind and smart guidance throughout this and really wish you all the best. Thank you so much. And welcome, Natasha. You're in for a ride and it's a good one.
Well, she's already met Arnold, so it's all good.
It's all uphill from there, Natasha.
Looking forward to it.
Thank you. Okay. Our next agenda item, our first true order of business, is the adoption of the December 3rd, 2020 minutes. Mr. Hakoda, Mr. Derrickson, have there been any written testimonies submitted on this matter?
Chair, this is Riley. No written testimony on the minutes.
Okay. Are there any members of the public who wish to testify on this matter? If so, use the raise hand function, or if you are dialing in, you can press *9. Recognizing Mr. James Bulka, who has raised his hand. This is regarding simply adoption of the minutes, not the next agenda item. I will admit you to be a participant in the meeting. If you can now enable your microphone and video, Mr. Bulk. Sorry, B-U-I-K-A. I don't know how to properly pronounce your last name. If you could enable your video and unmute yourself.
Getting there.
Okay.
Whoops. Mahalo. Good morning.
Good morning. And this is to testify on our adoption of the minutes?
No, I'm sorry. Next item.
Which item do you wish to testify on?
89-642.
Okay. I'm going to put you back to being an attendee, and I'll call you again when it's.
Sorry, I was over anxious.
No, that's okay. We're a fun group to be with. I understand completely. Is there anybody in the public who wishes to testify on the adoption of the minutes? If not, are there any comments or corrections? Seeing none, is there a motion to adopt?
Chair, this is Commissioner Wong. I move,
Commissioner Wong.
sir.
Commissioner Wong has moved to adopt the minutes. Is there a second?
Second.
Commissioner Ohigashi. Any discussion? If not, Mr. Ordenker, please do a roll call vote.
Thank you, Mr. Chair. The motion is to adopt the minutes. Commissioner Wong,
Aye.
Commissioner Ohigashi,
Aye.
Commissioner Chang,
Aye.
Commissioner Axon is absent. Oh, excuse me. Commissioner Okuda,
Yes.
Commissioner Cabral,
Yes.
Commissioner Giovanni,
Aye.
Chair Scheuer.
Aye.
Thank you, Mr. Chair. The motion passes unanimously.
Thank you very much. And Mr. Ordenker, will you please continue with the next agenda item, our tentative meeting schedule?
Thank you, Mr. Chair. On January 6th and 7th, we will be meeting once again by Zoom to discuss the Hokua Place matter. There's a motion for a protective order. And at that time, we will also be looking at the formation of a legislative committee with the Land Use Commission. On January 28th, we'll be hearing the Barry Trust matter. We're assuming that will also be by Zoom. February 10th, the Barry Trust adoption of order is scheduled. And the U of N Bencourt matter were request for us, the Land Use Commission, to be the accepting authority. On February 11th, we will be holding a hearing to discuss the handling of the City and County of Honolulu's important agricultural land submission, as this is the first time that we've been handed a decision by the county, a county. We felt that it would be best to hold an informational meeting to discuss how staff feels that matter should be handled, and so that the public can fully understand how we will be proceeding on that matter. The actual substantive hearings on that matter are scheduled for February 24th and 25th. March 10th and 11th, we will also be hearing anything associated with the Hokua Place matter that has not been finalized. March 24th and 25th, we also have the Oahu IAL matter scheduled, and that takes us through till April, and the calendar from that point on is in flux.
Okay, thank you very much, Dan. Are there any questions, commissioners, for Mr. Ordenker regarding our schedule? Mr. Giovanni, Commissioner Giovanni.
We also have some mandatory training.
Yes, but that's not part of the Land Use Commission schedule. Riley, we should have be sending you some information with regard to the training that certain commissioners are required to take up, in particular the Native Hawaiian law training. And I think Commissioner Giovanni, is there anyone else, Riley? And Natasha will be attending those sessions by Zoom.
Just offhand, do you know the dates? I don't need any more detail now, other than the date.
I'll resend it.
Riley will resend the email,
January 11th.
but it's January 11th and 12th.
And I hate to break it to you, Commissioner Giovanni, but I've been asked to speak as a lunchtime speaker there. So you'll be subjected to me once more.
I'll take leave, that's okay.
Any other questions, commissioners? If not, our next agenda item is continued action regarding docket number A89-642, C. Brewer Properties Incorporated, Maui, to consider petitioners Wailuku Plantation LLC, Edgar Somera, Faye Somera, Larry S. Sky, Daizhang Zhao, Zhu Jiang Fong, Bonghua Shi Jordan, Weng Zhao Liu, and Elise Travis's motion for an order bifurcating docket number A89-642. Will the parties please identify themselves for the record?
Good morning.
Good morning. My name is Jason McFarland. I represent the petitioners in this matter that you just, the names you just mentioned.
Good morning, Mr. McFarland. Mr. Sakamoto?
Thank you, Chair. Randall Sakamoto, representing co-petitioner RCFC Kehalani.
Maui County.
Michael Hopper, Deputy Corporation Counsel, representing the Maui County Department of Planning. With me is Deputy Planning Director Jordan Hart.
Nice to see you, Mr. Hopper. Office of Planning.
Good morning, Deputy Attorney General Donna Puna on behalf of the State Office of Planning. Here with me is Aaron Setogawa.
Thank you very much. Before we continue, let me update the record on this matter. On September 9th, 2020, the Commission met via Zoom conference technology to consider the petitioner Wailuku Plantation's motion for an order bifurcating this docket, and we voted unanimously, 8-0, to defer the matter until November 19th, 2020, with position statements to be filed by November 5th, 2020, and the chair was authorized to sign the deferral order and to approve any extension requests at my discretion. On September 22nd, 2020, the Commission received Wailuku Plantation's response to the LUC's request for information made at the September 9th, 2020 meeting. On October 5th, we issued its order deferring decision-making on this matter. On October 9th, we received the County of Maui Planning Department's errata to their position on Wailuku Plantation's motion. On October 21st, the Commission received petitioner KCFC's response to the LUC order deferring decision-making, as well as their exhibits 1-5. On October 29th, 2020, the Commission received the original verification of Brian Ige in support of petitioner RCFC's response. On December 1st, the Commission received the County of Maui's response to Kehalani's response to the LUC. On December 8th, the Commission received the party stipulation regarding the decision and order dated December 7th, 2020. On December 14th, the Commission received the original signature pages for the proposed stipulated decision and order. On December 17th, the Commission mailed the agenda notice for our December 30th, 2020 meeting to the parties and to our statewide email and Maui mailing lists. And we also received the Office of Planning's position in support of the petitioner's motion for the order bifurcating docket number A89-842. Now, having updated the record, let me briefly describe our procedures for today, which will consider the timely filed motions to intervene. No, sorry, excuse me. Kalamai. Let me just briefly describe our procedures for today. First, I will give an opportunity for the petitioner to provide comment on the Commission's policy regarding reimbursement of hearing expenses. Then I will allow for anybody to who wishes to provide testimony on this matter, including the earlier self-identified individual to provide testimony. As people are called in to testify, I will swear you in, ask you to identify yourself by name and address, and allow you to testify. After your testimony, you will be asked to stay available for questioning by the petitioners, the county, the Office of Planning, and the commissioners. After the completion of public testimony, Mr. McFarland will make his presentation in support of his motion. After Mr. McFarland's presentation, we will hear from Mr. Sakamoto. After the completion of Mr. Sakamoto, we will hear from the county and then the Office of State Planning. And finally, after all parties have presented their arguments on the motion of the order to bifurcate, the Commission will conduct our deliberations and possibly issue a decision on the motion. Parties, are there any questions on our procedures today, beginning with Mr. McFarland?
No, Chair, no questions.
Mr. Sakamoto?
No questions, Mr. Chair.
Mr. Hopper?
No questions, Chair.
Ms. Apuna?
No question.
Okay, thank you. Mr. McFarland, have you reviewed Hawaii Administrative Rules 1515 45.1 with regard to the reimbursement of LUC hearing expenses, and what is your position on this?
I have no position on that, Chair. We've already addressed the expenses pertaining to this matter, so
Okay.
I don't have
Thank
any.
you very much. Thank you very much. That's sufficient in our record. Now to public testimony. If you would, again, use the raise your hand function in the Zoom attendee meeting room if you wish to testify on these matters. Recognizing Mr. Buika, followed by Livett Calentine. I'm going to promote you to be a panelist again. I'm going to ask you to enable your audio and video. Good morning.
Good morning. Aloha, Chair.
Aloha.
Commissioner.
Do you swear or affirm the testimony you're about to give is the truth?
Yes.
Okay, so if you'd state your name and address for the record and then proceed with your testimony.
Thank you. My name is James Buika. My address is 514 Como Ohia Street, Wailuku, Hawaii, in Kehalani.
Please continue.
Thank you. My testimony is on today's agenda item, A89-642. I would like to wish you all a healthy and happy new year, and mahalo for your dedication to the people in the state of Hawaii and Maui County for all you do. I know it's a tough job. I have submitted written testimony a couple days ago, which I'm surprised has not been received for your convenience. It includes a draft condition for consideration as part of this bifurcation request. And I will read this condition as part of my testimony for your condition today. At this point, I am against bifurcation unless the master developer for Kehalani is held responsible for its commitment to the LUC to fulfill its original conditions agreed to in 1990. That seems obvious, but sadly, it's not true from my perspective. If you include my condition, I will be for the bifurcation. My ask today is simple. To bifurcate is to dedicate. And what do I mean? The master developer has not dedicated the land for a Kehalani Community Center as required under LUC condition number 7, 1990. The master developer is far behind in dedications, with some major dedications as far in arrears as August 2005 from a major punch list produced by Public Works 15 years ago. My proposed condition creates a trigger for the master developer to meet its obligation to the LUC prior to bifurcation by completing all these required dedications. Sadly, from my past experience as a member of the voting member of the Kehalani Communities Association, we have not been promised a community center on 5 acres of dedicated land as required by the LUC, and it won't happen without this condition in place today, from what I understand. In conclusion, first, please ask about the status of the community center from the master developer. Please deliberate and vote to include the following condition required to protect the homeowners of the Kehalani Community Association and the County of Maui and its taxpayers. And I'll just conclude by reading this condition of approval that I'm proposing to you. So here it goes. That prior to the execution of the bifurcation of the 2 unrelated projects, Pi'ihana Project District 2 and Kehalani Project District 3 parcels referenced in the 1990 decision and order, this bifurcation amendment shall not be approved until A, the Kehalani Community Association receives the community center parcel of land from the master developer as part of this transaction under the original condition number 7 by the LUC in 1990 decision and order, and B, all outstanding Kehalani associated dedications are completed and confirmed in writing to the satisfaction of the County of Maui, Department of Public Works, Department of Planning, and the Department of Parks and Recreation. That's end of the condition. Mahalo for your time today. To please consider my request to include this vital condition as a trigger for the master developer to meet the conditions agreed to in 1990 with the LUC. Thank you. That concludes my testimony.
Thank you for your testimony. Mr. McFarland, are there questions for the witness?
No questions, Chair.
Mr. Sakamoto,
No questions, Chair.
Maui County,
No questions, Chair.
commissioners. Commissioner Ohigashi.
I call you James. I have a hard time pronouncing your last name too. Is that okay?
Sure, you can call me James. Well, Hawaiian pronunciation, Buika.
Buika. Okay, Mr.
Right.
Buika. Who do you want to dedicate it? Who do you want the community center dedicated to?
The land. The land should be dedicated to the Kealani Community Association to finance building a community center as part of a master plan development, or whatever entity should take it. But it's in condition number 7. And right now, the master developer is not planning on giving us the community center. And that's why I bought my parcel, for a master plan community, living in a master plan community with a community center. Many of us have no opportunity to meet each other here. It's just basically urban sprawl without a community center. So I'm going on, but hopefully I answered your question.
Right. Who will hold ownership then to the community center under your proposal?
To the Kealani Community Association.
Thank you. Commissioner Okuda.
Thank you very much, Mr. Chair. Mr. Puica, thank you very much for your testimony today. I have a clarifying question. When you use the term master developer, who can you name specifically the entity or person who you want to be directed to do these things?
Well, it would be the RCFC Kealani LLC. And I believe it's Everett Dowling is in receivership now. And Brian Ige, who I know, who is diligent and a good representative, I guess, of these guys here. So that would be that's hopefully clarifies it.
Yes, thank you very much for providing that information. Thank you, Mr. Chair. No further questions.
Okay. Commissioners, Commissioner Cabral.
Thank you. Trying to find the raise hand function. Sir, yeah, thank you for coming and testifying. It's really important we hear from the community. In terms of dedicating this to the homeowners association, you know, then forever, ever, then the homeowners association will have to pay the dues to maintain the upkeep, et cetera, et cetera. Has it been considered, and I'm not sure that, you know, there's so much history here. Has it been considered in the past that instead that this land should be dedicated to the county for so that the county Parks and Recreation Division could be the owner of it and maintain it into the future, and then therefore usable by the entire island?
Well, those are, excuse me, yeah. Okay, thank you for the question. Those are 2 options, and those are 2 options for moving forward. Right now, the bank owns it. The past master developer, Stanford Carr, claimed bankruptcy, walked away from required dedications in 2009, and now he's in McKenna and Turtle Bay and Big Island, wherever. But he left us holding the bag for $2 million worth of dedications that were his responsibility. And there are many more dedicated, there are millions of dollars of dedications that are not happening. But I think the Kealani Community Association, through a vehicle called the Community Facilities District, which I would promote, would raise dues or taxes on people here to envision and build out a community center for the public and for us that will be of value to us. So the other option is Parks and Rec, but Parks and Rec is very, very far behind on building out another park here. So, you know, Parks and Rec, Department of Parks and Rec has many, many priorities on Maui Island and very limited budget. And it would, I think, behoove because there is a taxing mechanism now in place in Maui to actually pay for it out of our association dues, as you asked, to develop a beautiful, worthwhile community center for the community. And it would meet the vision of the Land Use Commission in 1990, I believe. Thank you. Hopefully that answered your question.
Yeah, thank you for your input. Thank you.
Commissioners, further questions for the witness? If not, if I may, Mr. Buika, have you had the opportunity to review the proposed stipulated agreement between the parties on this matter that's posted to our website?
Yes, I have.
Okay.
And I realize it was sent by, it was sent to the community, I do believe. And I did read, I didn't read what was on the website, but it was a 6-7 page document. And I understand what is on the agenda today to bifurcate the two projects. And, but the reason I bring up my testimony is because it's a rare opportunity from 30 years ago that Kehalani is on the
I appreciate that.
Agenda. Thank you.
So, but specifically my question was that you know, and I will intend, and I'm sure my fellow commissioners will intend when we question the parties in the county to get into these matters further, but the construction of the stipulated agreement does not waive any conditions. It does separate the assignment of conditions between the two parties in the bifurcation, but any condition that was part of the original docket is not waived in this particular stipulation.
I understand that. May I respond to that? May I respond to that?
Yeah.
Yes, I fully understand that. But, and all I'm saying in my condition is to create a trigger for the master developer to meet its obligations, because our past experience is they will take their money and run. They are just about finished with the homes here, and they have millions and millions of dollars of dedications before them. And they will claim bankruptcy in the pandemic, take their money and run and leave the county, KCA, and the LUC holding the bag. It's happened before, and it will happen again. And that, I believe, is the truth. And that's why I'm testifying today, because we need the trigger. This is a good trigger. Thank you.
Thank you so much for your testimony. Very much appreciated.
Thank you.
Any further questions, commissioners? If not, I'm going to put you back to being an attendee and bring in our next
Mahalo.
Witness, Livet Callantine. If you can unmute yourself and turn on your audio or video.
Aloha.
Aloha and good morning. Do you swear or affirm that the testimony you're about to give is the truth?
Absolutely.
Okay. I think you know the drill. Name and address for the record, and then testimony.
Yes. My name is Livet Callantine, and I live at 631 Mayakanu Lane, apartment 101 in Wailuku. This is, I'm one of, well, okay. Should I just start?
Yes, please.
Okay, sorry. I'm just going into it. First of all, I want to thank the previous testifier for his testimony. I very much support what he had to say. I wanted to correct, he referenced condition number 7 of the 1990 DNO, and it's actually condition number 10. just to clarify in case anyone was confused as I was about that. I am one of the original owners of Kealani Gardens. It's a neighborhood of 132 workforce housing units, which was constructed in the Makai portion of the Kealani Project District. I bought my condo in 2005 and I've lived here continuously. My neighbors are nurses and technicians, public safety employees and teachers, hotel staff and service workers. I did submit written testimony yesterday, but from comments made, I'm not sure that you had a chance to review it. I checked this morning and it wasn't yet posted on the LUC website. So I'm very sorry because I went into some great detail there about several issues. But I had determined, given the time limitations, that I would focus my remarks today on the subject of parks. When I submitted the testimony yesterday, I wanted to just reiterate something that is in my written testimony, which is that I have no objections to the bifurcation proposed once I and others are assured that unfulfilled promises to the community and representations and conditions made before the Land Use Commission have been satisfied. Specifically, the Kealani community was promised and desires a community center in order to gather, hold meetings and events. There are several sub-associations within Kealani, and I am in one such, and there are boards of directors, and we were promised a place to hold our boards of directors meetings, and that has not happened. So we've been forced as a workforce housing community to go out and rent space to hold our meetings because of the developer didn't provide us on site a gathering spot. So to turn to the, and I support the condition that was proposed by Mr. Buca. Well, within the Wailuku Project District, Kealani is comprised of a large aggregate parcel, Mauka of the Hono'opilani Highway, and that is referred to as Kealani Mauka, and another aggregate parcel, Makai of the Hono'opilani Highway, and that is Kealani Makai. Within Kealani Makai, one parcel has been dedicated to the County of Maui as a park. However, this Makai Park, and I say that in quotes, it's approximately 7.5 acres, and it should more appropriately be classified as a drainage basin. That is what it functions as. Every time it rains, it's full of water. It'd be a great place to store your boats. It has been closed under padlock for a very long time. I've never been in the park. It's across the street from my unit. It is undeveloped, and it is the only park planned in the Makai portion of the Kealani Project District. And it's a very dense portion of the project district. This is the more lower end homes, and we are denser here, and we need more open space. The only lucky user of the park, in case you haven't ever heard this, is a herd of goats. I kid you not. There's a herd of goats. I don't know where they came from, and they are there using the park, having a great time, and it'd be nice to go in there and walk around with them. Anyway.
If you could summarize your testimony.
Yes. Neither the owners within Kealani nor the community at large have access to this park. Therefore, this 7.5 acre parcel should not be counted as fulfilling the park's obligations set forth in Finding of Fact 85 of the petitioner of the January 30th, 90 order, which reads, petitioner proposes to develop and dedicate approximately 110 acres of parks and open space, as well as a community center within the Wailuku Project District. I will just close by saying that 27 acres, which is the amount of acreage that you were provided in a document from the County of Maui's Planning Department that was dated 12/1/20. And the document is labeled Kealani Park Summary, and it concludes that 27 acres of land have been dedicated for parks within the Kealani Project District. Well, this may satisfy the county's requirements for parks. 27 acres is a far cry from the 110 acres of park and open space required by the 1990 decision and order. Where are the additional parks? The condition number 10 requires substantial compliance. I do not think 27 is substantially compliant against the total of 110 acres promised.
Thank you, Ms. Carrington.
And consideration of my testimony.
Thank you very much. Are there questions for the witness from Mr. McFarland?
No questions, Chair.
Mr. Sakamoto.
No questions, Chair.
Mr. Hopper,
No questions, Chair.
Ms. Apuna,
No questions.
commissioners. Commissioners. If not, this is more of a response, Ms. Callentine, than a question for you. But part of the dilemma that the Land Use Commission has is that once an area has been substantially developed, we lack enforcement power. We have repeatedly sought at the legislature to have enforcement power, to have conditions required, but when conditions need to be enforced against, or there's a question of whether or not conditions have been met for areas where substantial commencement of development has occurred, that then falls to the county in question rather than to the commission itself. We have, and I think we'll continue to seek greater powers of enforcement, but just as transparency, we do lack, I think, some of the remedy which you would seek us to impose.
Thank you.
Okay. Is there anything further, commissioners? If not, thank you very much for your attention and for your testimony and for taking the time to be with us. It's very valuable.
Mahalo.
I will now move you back in. Is there anybody else who wishes to provide public testimony on this matter? If so, I am going to recognize Karen Fainouf, and you can correct my pronunciation when you come in. If you can enable your audio and video.
Oops.
There, I can see you. Good morning. Aloha.
Hi, good morning.
Do you swear or affirm the testimony you're about to give us the truth?
Yes, it is.
Okay, if you would state your name and address for the record and proceed.
My name is Karen Fineff. I live at 550 Akulea Place in Wailuku, which is the Kaimana section of the Kehalani neighborhood. I would like to support both of the people who just testified. I did also submit testimony yesterday. Was that received?
If we may, I'll ask further confirmation from the commission, but I will say due to the pandemic, we don't have many physical staff in the office receiving things. So things that are submitted right before the hearings, unlike in non-pandemic times, sometimes are not fully processed. Mr. Hakoda?
Will you be able to take a look at that before you make any decisions?
Mr. Hakoda?
Yes, Chair.
Has there been written testimony received as indicated by the witnesses?
I checked yesterday's emails to the commission and did not see any emails addressed to the commission in our inbox. So I'm puzzled by how testimony was provided to the commission.
Okay.
Well, it's via email.
Okay.
If it was via email, if it came in after I did a sweep in the late afternoon, it may not have cleared the server in time to be noticed by me. I apologize. I will recheck our server inbox again after this meeting concludes.
Okay. If you would, I'm going to restart the time if you want to, though, share with us orally your concerns.
Sure, thank you. My concerns are basically very similar to those of Jim and Livett. The community center has been promised. It never has come about. The park at the Mackay Park has been promised. It's been locked up for 7 years. We did used to use it before, and now it's locked up. We cannot use that. The roads have not been dedicated. The crosswalks are unpainted. Basically, the developers have been, like Jim said, making their money, running away, and leaving us with whatever is left over. The residents have had no attention whatsoever from the developer, it seems. So I've lived there since 2000. I love my neighborhood. It's a wonderful place. We really, really love to gather, and we think that a community center, a park, the things that we step for should be mandated. I understand you don't have enforcement power, but the county has just done this again and again and again without really following through, I think, on the conditions. And so please, I hope you can find my written testimony also. And I want to support Live It and Jim and all my neighbors.
Thank you very much. Are there questions for the witness? Mr. McFarland?
No questions, Chair.
Thank you. Mr. Sakamoto?
No questions, Chair.
Mr. Hopper?
No questions, Chair.
Ms. Apuna?
No questions.
Commissioner, starting with Commissioner Okuda.
Well, thank you very much, Mr. Chair, and thank you, Ms. Pinoff, for your testimony. Can I ask you this? The different groups of owners that live in the community, do you have like organized or elected boards of directors, like your area that you live in? Is there like a elected board of directors or community association elected by the residents of the community?
Yes, we have an elected board, a homeowners association. It's a little bit dysfunctional. We each have a representative, or we should have a representative for each section. At this point, they deny us representation if we don't have enough votes. And right now, a lot of people just haven't voted lately. So I think it's a very small board right now.
Okay, whether you have an active board or a more informal board, would it be fair to say that there is at least some organization of residents who get together to discuss community concerns? Would that be a fair statement?
I think that's a fair statement.
Do you know of do you know whether or not the developer has attempted to talk with residents about these issues that are being raised now during this public testimony? Have there been any discussions that you're aware of between the developer and the community about these concerns?
I am not aware of anything except for that paper that we received in the mail, the bifurcation, frightening 6-page, whatever that was, that we didn't really understand. I am not aware of any attempt made to just have a meeting or even get together virtually to talk about this. That's a good question.
Yeah, oh, okay. I'm just trying to find out whether or not there was any outreach or attempt by the developer to communicate with the community. Let me ask you this, and I apologize if this is just sprung on you, but it kind of popped into my mind right now. Do you think there would be anything that would be harmful, or whether it might be helpful, if for some reason this matter about bifurcation was continued by the Land Use Commission to a later date to allow the developer to try to address these concerns with the community? Would no guarantees that that would actually work out to any positive agreement? You see anything harmful to the community by saying, okay, let's put this request for bifurcation and have it heard at some later date next year, and give the developer time to meet with the community to see whether or not you all can reach a mutual agreement, to see how this community will move forward from a development standpoint?
I feel like it's not been bifurcated for a very long time, and I don't think a few more months would make a difference. I think we would love to talk with my community would love to talk with anybody. We've been talking amongst ourselves for a long time and feel like we're not really being heard.
Oh, okay. I do share the chair's evaluation of the state of the law, which is the fact that under this case called Bridge Aina Lea, the Hawaii Supreme Court has made it pretty clear that if there is substantial use of, or if there's substantial commencement of use of the property by an applicant, the power of the Land Use Commission to revert the boundary designation is very limited or must follow a more complicated procedure. So the chair's evaluation of enforcement powers, I do believe is correct. But I might just add to it that at the same time, I believe the commission has the discretion when a party is asking for leave or certain treatment or certain remedies from the commission can also take into account all other facts in deciding whether or not to grant what the applicant is asking for. So without getting too technical, let me just say this. Thank you very much for spending your time and giving your testimony. Democracy always works better when everybody. Thank you, Mr. Chair. No further questions.
Thank you. And I'm just going to, for this witness, as well as for the written testimony of Ms. Callantine, that's now been electronically delivered to our mailbox. Okay. There was some kind of delay in the state's server, which was beyond our staff's control. Are there further questions for this witness from the commissioners? If not, thank you very much for, again, as echoing Commissioner Okuda, taking your time to participate and giving us your ideas. Really appreciate it. And happy New Year. Okay, I'm going to move you back to being an attendee. Are there any further individuals who are attendees who wish to provide public testimony on this matter? If so, use the raise your hand function. If there are none, then I will close public testimony on this matter, declare a 10-minute recess till 10:02 a.m., and we will resume with presentation by Mr. McFarland. Any concerns with that procedure? If not, public testimony is closed. We are going to take a 10-minute recess, resume at 10:02 a.m. Okay, it's 10:02 a.m. We are back in session. And we're going to begin with the presentation from Mr. McFarland.
Good morning, LUC panel members and members of the public. At the last hearing, we heard petitioner's motion for order bifurcating docket number A89-642. At that time, a number of questions and concerns were raised about the bifurcation, and that's why we continued this matter until today. Since then, the parties, RCF CK Halani LLC, petitioner, my client, the County of Maui Department of Planning, and the State of Hawaii Office of Planning, we've entered into a stipulation decision and order, which I believe the LUC received on December 8th. This was basically a negotiation between the parties, and one of the issues that did come up during the stipulation negotiation was Kehalani. I'll let Kehalani LLC speak for themselves, but there was an update on the status of the remaining conditions, and the remaining conditions were addressed in that stipulation. In terms of petitioner, my client, we've also stipulated to.
Sorry, Mr. McFarland, is there like a lot of background noise and?
There's a lawnmower going by every few minutes. I think it's about done. I'm sorry about that. I'm pretty sure it's about done. I think that's
There's a deep reverberation I'm hearing from, okay.
Yeah, that's the lawnmower. I'm pretty sure that's the last time. My apology.
No, it's fine. Please continue.
Okay.
It's 2020.
Yeah. Well, in terms of my client, the concerns raised at the previous hearing regarded my client's ability to fulfill the conditions as they've been set forth in the 1990 DOA, and my client's demonstrating my client's financial capabilities to fulfill these conditions, as well as updating the LUC on progress and timelines towards achieving these conditions. As part of the stipulation, my client has agreed to 3 conditions within the stipulation. Within 6 months, the Pi'ihana Project District petitioners shall provide a statement of current costs for the remaining development and improvements and a detailed schedule for necessary approvals and development. Number 2, verify the financial capability to complete the development according to LLC rules and the 1990 DOA conditions. And also provide a report detailing how substantial compliance with the conditions are being achieved. And within the stipulation, there's been a 6-month petitioner is to provide all of these things within 6 months to the LUC. Again, all the parties, the State of Hawaii Office of Planning, County of Maui Department of Planning, RCFC Kehalani, they've all signed on to this stipulation, as I have for petitioner. Just to recap what this motion for order bifurcating docket number A89-642 is about. This is a procedural matter to bifurcate the current docket between the Pi'ihana Project District and the Kehalani Project District. Kehalani would maintain the current docket number. The Pi'ihana Project would get a new docket number and also incorporate all pleadings, papers, legal memoranda, exhibits, and filings for docket A892-642 into the new docket. In other words, Pi'ihana Project District and Kehalani will remain obligated to fulfill all the conditions as set forth in the 1990 DOA, and there is none of the conditions have been eliminated. The other purpose of the bifurcation is that Kehalani and the Pi'ihana Project District shall not be jointly subjected to any decision or order issued by the LUC, so that LUC decisions made shall apply solely to the Pi'ihana Project District or Kehalani Project District under their respective docket numbers. I think the testimony we heard today provides good cause for bifurcation. As we see, there's a variety of issues that came up today regarding the Kehalani Project District that don't apply to the Pi'ihana Project District, and this would make it, I think it would make it clearer when the LUC would be addressing matters within their respective project districts to, when issued orders, made decisions, conducted hearings and so forth, they'd be targeted towards one project district or the other. We've also believe we've established good cause for the bifurcation pursuant to HAR 151571. Pi'ihana Project District and Kehalani are non-contiguous parcels. Both developments are in entirely different stages of developments. We have different issues. Kehalani, as you're aware, has largely developed, and Pi'ihana Project District is largely undeveloped. The two project districts have entirely different owners. RCFC LLC sold out their entire interest to petitioner Wailuku Plantation LLC between 2017 and 2019. RCFC no longer has any ownership interest in the Pi'ihana Project District. In the Pi'ihana Project District, as it stands today, my client Wailuku Plantation LLC still owns 75 acres, and there have been parcels sold off to other owners of about approximately 3 to 4 acres. Wailuku Plantation LLC is not affiliated with Kehalani LLC. We have no plans to work together on these projects in the future. And I would just like to point out that all the Pi'ihana Project District owners of these new lots that have been sold off have consented to my representation. I've provided attorney authorizations with the LUC for all of the individual owners in the Pi'ihana Project District, and I've made myself available to answer their questions. And that's about all I really have for you guys today, LUC. I think in the stipulation, we've addressed the concerns that were raised at the previous hearing, and I'll open it up to any questions you guys might have at this time. Thank you.
Commissioners, questions for Mr. McFarland? Commissioner Chang, followed by Commissioner Okuda.
Thank you, Mr. Chair. Good morning, Mr. McFarland. Thank you for your testimony. I'd like to ask you, are there other properties within the 75 acres that are for sale?
Yes, there are.
So are you making disclosures of this proposed stipulation and the existing LUC-DNO to those prospective buyers?
Yes, we are. As a matter of fact, the buyers often consult with the County of Maui Department of Planning about the progress of the development. So yeah, they're aware of the status of the property, and we make disclosures as far as the conditions that need to be satisfied.
Okay.
Remaining conditions.
All right. Thank you. So any new owners who may purchase, you don't necessarily represent them. Is that correct?
I don't represent them. I did submit documentation about realtors that list properties down there. That's a little beyond my control, but there are primarily 2 different realtors who are marketing properties down there that work with Mr. Lindsay. He's the sole member of the Wailuku Plantation LLC.
Okay. All right. So you've done everything that you can to disclose LUC's existing conditions and the proposed stipulation so that any buyer is aware of both the existing LUC conditions as well as the proposed stipulations.
That's correct. I do make myself available to answer questions to current owners and prospective owners as much as I can. I have been contacted regularly.
Okay, no, thank you very much. I have no further questions.
You're welcome.
Thank you.
Commissioner Okuda.
Thank you very much, Mr. Chair. Thank you, Mr. McFarland, for your presentation. When your client purchased its interest in the property, it was aware that the property is subject to the decision and order which the original petitioner and landowner, C. Brewer and Company, obtained, correct?
That's correct. Fully aware.
Okay, and you know, in hindsight, given what's taken place, you know, reasonable people might question whether C. Brewer and Company should have had these two different project districts presented in a single docket, but C. Brewer presented the boundary request the way they did, and the order was issued based on what C. Brewer and Company submitted to the Land Use Commission. You agree that's a fair statement?
Yes, that's correct. That's my understanding.
Okay, and I'm not saying that a court or even the Hawaii Supreme Court would ultimately rule a certain way, but you do agree that there is an argument that because your clients are successors in interest to the original order that C. Brewer and Company obtained, and Mr. Sakamoto's clients are successors in interest to the original order that C. Brewer and Company obtained, that your respective clients might have obligations with respect to each other's development. I mean, there is at least that argument, correct?
Yes. Yes, there is that argument. I
And
believe that's
in fact, that's one of the reasons why at least your client is asking for this bifurcation, so that going forward, there's not going to be any responsibility for what happens at the other project, correct?
yes. Yes, that's correct. My client isn't working with the Kehalani representatives and doesn't have any plans to work with them on either development. They proceeded independently.
Okay, but in any event, and we see this sometimes when people buy into companies or buy interests in property, that when you have additional buyers, sometimes there are more people that become responsible for an obligation which runs with the land. Would you agree that's a fair statement, just as a general principle?
Yes. Yeah, we're aware the conditions do run with the land.
Yeah, okay. So in other words, if the Land Use Commission grants this bifurcation, what the Land Use Commission really is doing is limiting potential remedies that the citizens of or residents of Maui who buy into either of the projects may have. In other words, the commission, by granting this bifurcation, may be limiting the potential people that homeowners can hold responsible. Is that would that be a fair statement?
Yeah, I'm following you. Could you rephrase that and make it a little more concise? But I think I do agree with you.
Yeah, let me put it in plain English. In other words, if this bifurcation is approved, the Kealani developer can claim that they're not responsible for any claims or arguments your purchasers may have, and also vice versa. In other words, right now, you might be held responsible, or your clients might be held responsible for what takes place or doesn't take place in Kehaulani, and basically could be sued by homeowners there. But what the Land Use Commission will be doing is taking away some of the remedies that homeowners may have. Would that be a fair statement?
Yes, that's correct. Yeah,
Okay.
right now.
Okay, then let me ask you this. If the decision to bifurcate these cases will be taking away potential rights and remedies that homeowners who buy into this project or who have bought into this project have, what is the community getting in return for us granting this bifurcation? What's the benefit of the bifurcation to the community? I'm not asking about the bifurcation to the developers. I'm asking about what's the benefit of the bifurcation to the community.
Well, I think it would, it's kind of a hindrance to Kehaulani to be tied to the Pi'ihana Project District to proceed because of liabilities attached to that project district. And the same would be true vice versa for my client to be tied to the conditions and responsibilities in Kehaulani. My client is aware that the conditions do run with the land for the Pi'ihana Project District, but I don't think there was any intention on his part to take on the obligations of the Kehaulani Project District. So,
yeah, well,
but benefit to the community. I hadn't. The respective owners, individual owners of each parcel can address matters with the LUC and the Maui Planning Department specifically pertaining to their project district, as opposed to when a issue comes up, it jointly applies to Pi'ihana and Kehaulani. That's one benefit I can think of.
Oh, okay. Well, can you think of any other benefit the community gets in exchange for the rights that it may be giving up if this bifurcation is granted? Any other benefits that the community gets? And I'm not talking about the developer's benefits or the benefits the developer gets. It's, can you think or tell me of any other benefits that you can point to that the community gets from this bifurcation?
I don't have any answer for that at this time, Mr. Okuda.
Okay, thank you very much for your answers to my question. Thank you very much, Mr. Chair. No further questions.
Thank you very much, Commissioner Okuda. Commissioner Ohigashi.
So my question is basically this, is that Mr. McFarland, since the last hearing, I went past I drive past that area that client's property is on, going down there to the Wailuku industrial area. And so I think once or twice I've seen cars burning. There's been burning cars on your property. Are you still maintaining, or is your client maintaining some kind of car disposal area there? Or I'm just curious because I live here.
No, that particular plot piece of land is Makai to the Pi'ihana Project District. That's a different parcel of land where the burning is taking place. There is a homeless community that's been down there for decades, and that homeless community is increasing during the pandemic. And yes, there has been fires down there, and
that parcel is not yours.
That's outside of the Pi'ihana Project District. It's Makai.
And I have another question, which Commissioner Chang brought up. How many more parcels are up for sale at this?
To my knowledge, there are approximately half a dozen properties for sale at this time. Some of the owners who initially bought are trying to resell their parcels too. So yeah, there's parcels that are marketed in an ongoing fashion by realtors down there.
I understand that, but in addition to the already sold parcels, how many other parcels are?
As far as new parcels, to my knowledge, one more. What Mr. Lindsay will get a tax map key from the county and sell the parcels one by one is how things are going down, occurring.
And Mr. Lindsay acquired this property by foreclosure, through a foreclosure sale?
I don't believe so. He bought it from RCFC LLC. I don't think there was a foreclosure involved when he purchased the property.
So he was transferred all rights and responsibilities under the terms.
That's correct.
I guess the deed.
That's correct.
Okay, no further questions.
Thank you, Commissioner Ohigashi. Are there any further questions at this time for Mr. McFarland? Commissioner Cabral.
Yes, thank you, Chair, for moving forward. Mr. McFarland, you referenced that there are maybe a dozen properties for sale. Now, there's the two different properties the two different entities that we're discussing. How many are those on, that's in total on both sides, or just on the Pi'ilani property side? Which is it?
Yeah, I'm just speaking about the Pi'ihana Project District. And actually, to clarify, it's my estimate that there's 6 properties for sale down there right now. And some of those are being resells, like they were already sold once and now they're being marketed again. So there's about 6 properties down there for sale.
Okay, but none on the Lindsay side of the property then?
I'm not sure what you mean. I'm speaking within the Pi'ihana Project District as a whole. All 6, those are the 6 properties. I don't know what you mean by the Lindsay
Well, I'm just
side.
trying to, can get a little confusing there. It's, you know, bifurcating and which half has what going on.
Yeah.
So, okay, so 6 on Pi'ilani's side. Thank you very much.
You're welcome.
Commissioner Giovanni.
Thank you, Chair. I'm testing my memory a little bit on this docket, but I recall one of the conditions was the building of a bridge that was responsibility of the Pi'ilani district. And there was no clarification at our last hearing whether Mr. Lindsay had the financial wherewithal to actually build that bridge without selling property off. And now we're seeing by terms of the stipulated agreement, we will not have verification that he has a plan or any funds to actually complete that important condition until 6 months after we would approve the stipulation. Am I understanding that correctly?
Yes, I believe that is correct. Right now, as it's set forth, Pi'ihana Project District is to provide financials to the LUC within 6 months. You know, my client has actually been fairly transparent. One of the issues that came up at the last hearing too was a suggestion that this property would be reverted to agricultural zoning. And my client has taken the initiative, and he has approached the County of Maui Department of Planning about this. And at this time, that's my understanding where this project district will be going. Just to be upfront with all of you guys. So he has diligently tried to pursue financing, tried to pursue contractors. We've done a lot of work on that end. This project district requires hundreds of millions of dollars. And hey, Mr. Lindsay doesn't have hundreds of millions of dollars. I'm going to tell you that right now. That's just a fact. We all know that. I'm not going to, no need to beat around the bush, but that's my understanding is he is voluntarily going to revert the zoning to agricultural, and he has it's just more money than he anticipated this whole thing costing. It is what it is. That's just a fact.
Thank you. No further questions.
Do you have any more questions?
No.
Thank you, sir.
Commissioners, are there further questions for counsel for Mr. Lindsay at this time? For the petitioner, Commissioner Chang.
Thank you, Mr. Chair. Mr. McFarland, you just said something that I wanted some clarification. So is it your statement that Mr. Lindsay intends to revert after the bifurcation, intends to revert this Wailuku Plantations property back to ag?
Yeah, he's already approached the County of Maui Department of Planning about this matter. That's so he's
okay. And has that disclosure been made to all the realtors as well as prospective buyers that this land is now the intention is to revert everything back to ag?
As far as I know, that's what has been told to me, that they're making proper disclosures.
And is it clear that there will be different restrictions if the property is ag zoned versus what it currently is zoned? For any current buyer, any current owners, as well as new buyers? Does Mr. Lindsay understand that?
Yeah, I believe he does understand that.
Can you explain to me, what do you think he understands? What do you think he understands?
I can't speak to that, but I would suggest that if you guys want to have a hearing with Mr. Lindsay, then we can set that up. But he does own agricultural land around Hawaii, so he is well aware of the ramifications of agricultural zoning.
So, Mr. McFarland, just to be clear, you represent several of the owners that have bought land, as well as you represent Mr. Lindsay, who owns Wailuku Plantation LLC?
Yes.
Have you spoken to Mr. Lindsay prior to this hearing?
Yes. That's when he made me aware that he had made this proposal to the Department of Planning.
Okay. And let me just ask you one final question. Currently, the landowners that you represent, have there been any improvements on the land are they building anything? Is there any structures? Is there anything on the land by either Wailuku Plantation or by the individual owners that you represent?
Yes, there is.
And what is on the land? What has been done on the land?
There is one freestanding house, and there are 2 mobile dwellings, like tiny house structures that can be moved.
Okay.
That's what's down there at the moment.
Are they legal structures? Were they built with county permits?
Not to my knowledge. I don't believe so.
And are they aware that if an enforcement action is taken by the county to require them to remove them, that they may be required to remove them?
Yes, they are aware. That's
All
that's a big significant concern.
Okay. All right. Okay, Mr. Chair, I have no further questions. Thank you, Mr. McFarland.
Thank you, Commissioner Chang. Commissioner Ohigashi.
Mr. McFarland, are you intending to file then a petition to revert that portion, your project, to agricultural district under the Land Use Commission?
That's what Mr. Lindsay represented to me, that's the direction he wants to take the Pihana Project District. It was previously ag.
So if we decide to bifurcate and add a condition that the petition, that your client will be filing, with the understanding that your client will be filing petition to revert to agricultural district, would that be objectionable to you?
I'd prefer we had a hearing about that. Mr. Lindsay does change his mind from time to time, as we saw in other hearings. So I'd like to have him here to speak for that himself.
Well, this is the hearing where we're going to decide whether to put the condition in. So isn't it your duty to have Mr. Lindsay there to respond?
Yes.
You're the one bringing it
no,
up.
I understand. Yeah, no, I did make him aware of this hearing. I can tell you that. And I'm here representing him, so as best I can.
I don't have,
But
I don't know what to say. I don't know what to ask. I will stop here.
Yeah, I'm trying to answer these questions as best I can. It's just all I can do.
Commissioners. Yeah, I guess, Mr. McFarland, I'm just going to observe 2 things and I'll give you a chance to respond to my reaction. First of all, I'm a bit perplexed by your statement. Mr. Lindsay has been very transparent with us, and then comma, by the way, he's thinking of reverting the property. This is the first time I've heard it. So it doesn't lend to me evidence that he is being transparent with this commission. I also just want to note for the, let me finish, Mr. McFarland, because I don't think you've actually fully comprehended the commission here before this entire time. The second thing I'd like to note is that every time a parcel is sold, those parcels are still currently under the full obligations of the entire decision and order. And every time a parcel is sold, the landowner is deliberately limiting his ability to fulfill those conditions. Deliberately and knowingly. You may respond.
What was the question, Chair?
It was a statement, Mr. McFarland.
I don't have, you know, Mr. Lindsay let me know about the reversion to ag status about 3 weeks ago when I made him aware of this hearing. And he's met with the County of Maui Department of Planning about it. That's what I can tell you.
Is there anything further? Mr. Okuda, Commissioner Okuda.
Thank you very much, Mr. Chair. Following up on this sudden disclosure, Mr. McFarland, about Mr. Lindsay's intentions, may I ask you this question? Did you communicate to the other parties, Mr. Sakamoto, the county corporation council, the state office of planning? Did you tell them that this was now Mr. Lindsay's most current intentions?
I haven't. I've only discussed it with Mr. Lindsay. I don't represent him on that matter, but he has made it. He made me aware that that is something he's pursuing on his own.
Don't you believe that the intention to revert part of, or to revert his part of the property back to agriculture is a material fact which the other parties should have been made aware of, because it may or may not affect now the substance of the stipulation, which appears to have entered into based on an understanding of or without an understanding that there would be a reversion. I mean, isn't that something material to the stipulation?
Yes. Basically, Mr. Lindsay has told me he doesn't have the financial ability to do this project. So that's where.
Yeah, I know. But my question is simply whether or not the intention to revert the property of the people that you represent back to agriculture, that intention is a material fact that the other parties to the stipulation should have known about, because it might affect their willingness to even go forward with the stipulation, or maybe affect whatever conditions they would have been willing to stipulate to.
That's correct.
Okay. Okay, maybe for once in my life, I'm a little bit speechless. Okay, Chair, I'm sorry. I've got no further questions.
Commissioner Ohigashi.
I just want to get this on the record. So when you sign the stipulation indicating that you will provide to the Land Use Commission within 6 months financials to show how are you going to complete this project, you knew that Mr. Lindsay did not have money to complete it, and that you probably would not be filing that 6 month.
He brought this up to me after the stipulation came about. I didn't know about.
You learned about this after the 14th, when the filing of the stipulation took place.
Yeah, after I signed the stipulation, he contemplated these requirements, these 3 requirements, and he told me, you know what, I've done everything I can. I've investigated this. I've tried to get the financing. I'm just not going to be able to do it. So I've approached County of Maui Department of Planning about reverting to ag.
I just want to say so. As of this point in time, you have no intention of, Mr. Lindsay has no intention of fulfilling the requirements under the stipulation that he provide financing plans within 6 months.
He said he would provide his financials within 6 months.
No, it's calls for a financing plan and showing how he can complete the project.
Yeah, you know, it's not going to be what, you know, just to be honest, it's not going to be everything you guys want it to be, but he said he
Commissioner Wong.
wants to provide the financials within 6 months.
Commissioner Wong.
Mr. Chair, I would like to move to executive session to discuss with our attorney about the legal issues and limits to our discussion on this issue, please. On this issue at hand.
There's a motion to go into executive session to consult with the commission's attorney regarding our powers and duties, and it has been seconded by Commissioner Cabral. Is there discussion on the motion?
Chair, this discussion is more on regarding the limits of attorneys' discussions and viewpoints that was presented to us. And I wanted to talk to our attorneys about his viewpoints to see that what the matter that was brought in front of us is okay or not okay.
Can I ask you to further clarify, Mr.
Chair,
Be direct.
I just wanted to ask our Attorney General his opinion because I have some concerns over Mr. McFarland's statements and his prior statements to the commission, if he is if he's lying to us or not, and if he knowingly knew about the lying in. So I wanted to talk to our attorney first.
Thank you very much for that clarified motion. Do you still second the motion, Commissioner Cabral? Okay, Commissioner Cabral still seconds the motion. Mr. Ordenker, is there a discussion on the motion, commissioners? If not, Mr. Ordenker, please roll call the commission on the motion to go into executive session.
Thank you, Mr. Chair. The motion is to go into executive session. Commissioner Wong,
Yes.
Commissioner Cabral,
Yes.
Commissioner Giovanni,
Aye.
Commissioner Okuda,
Yes.
Commissioner Ohigashi,
Yes.
Commissioner Chang,
Yes.
Commissioner Axon is absent. Chair Scheuer.
Aye.
Thank you, Mr. Chair, motion passes unanimously.
Okay, so for commissioners, you will be sent a separate meeting invitation from Mr. Ordenker to attend a different Zoom meeting. This meeting will remain open for all panelists, attendees. There will be a notice on the screen that we are going into executive session, and I cannot tell you how long that will last. We will then come back from executive session and resume our hearing. We're in executive session.
Okay, so I need to send to.
We were still on or finishing with questions for Mr. McFarland. Mr. McFarland.
Yes, I'd just like to say, I'm trying to be upfront about absolutely everything here. I think those who attended the LUC hearing previously with Mr. Lindsay and observed how he changed his mind and changed his intentions during the middle of the meeting, surprisingly to all of us. So I just want you guys to keep in mind, I'm dealing with a very indecisive and difficult client here, and I am trying to provide you with the best information I can. I'm answering your questions forthright. I really take great offense that I would be alleged to be a liar because I've, there aren't any good answers to these questions. There just aren't. And I'm doing the best I can with them. And I hope you realize this. Mr. Lindsay doesn't have copious amounts of money. He doesn't have the greatest plan. And I'm here doing the best I can. So anyway, thank you.
Thank you for your statement, Mr. McFarland. Commissioner Wong. You are muted, Commissioner Wong. You are still muted, Commissioner Wong. One moment while we try to address this.
Okay, Chair. So
Commissioner Wong.
Yes, Chair. I want to apologize to Mr. McFarland if I called him liar. It's just that I was just taken aback, and it seemed like it was misrepresentations by some statements that I just heard. You know, I was just thrown off my chair pretty much by what I just heard. And so please, I apologize, Mr. McFarland, for if I said that it's lying.
Okay, well, I'm not a liar. I'm going to answer forthright. You know, this letter and these appointments with Maui, the County of Maui Department of Planning, those are on record with the Maui County Department of Planning. If I was a liar, I wouldn't tell you about it at all. I figured I should bring it up now to be upfront rather than down the line in this meeting, somebody else brings it up and goes, hey, Mr. McFarland, what about this? Why didn't you tell us that? So I'm bringing it up now. And I'm going to answer what I know to the best of my ability, and that's all I can do. And that's got to be good enough because I can only do my very best, and that's what I'm doing. That's it.
Thank you. Thank you, Commissioner Wong and Mr. McFarland.
I am honest. Thank you.
Any further questions right at this time for Mr. McFarland, commissioners? If not, let's hear from Mr. Sakamoto and for his client.
Thank you, Chair. I think I want to start out by perhaps responding to a question that Commissioner Okuda raised during the public witness testimony, which was what community benefit is there if the commission were to approve the bifurcation? So if I could, I would just like to say, in response to that, the Wailuku Project District, also referred to as the Kehalani subdivision, it consists of, many owners at this point, as we've explained previously. There are roughly 2,000 homeowners. Lots have been sold to the Carpenters Union and Foodland, and they've dedicated property to the County of Maui for these parks. They've dedicated land to the State of Hawaii Department of Education for school. And so, one of the benefits that would come out of this bifurcation is that the title to all of these properties right now is, as you know, is encumbered by the decision and order conditions. But because the DNO applies to two separate unrelated project districts, the question that arises that essentially clouds the title to all these properties is, what is the impact of one co-petitioner's non-performance of a condition on an unrelated co-petitioner on an unrelated project who is performing the conditions? And so this question to me can be addressed by the bifurcation, because essentially, that question would no longer exist if the commission would bifurcate the docket. We stated very clearly in the stipulation that it's a procedural matter only. It would support the just and efficient operation and proceedings of this commission, and it is not intended to affect any of the existing substantive rights or obligations of any of the parties. If a party has an obligation prior to the bifurcation, they would have that obligation after the bifurcation. There's no intention to try to escape something or be released from something by virtue of the bifurcation. We're simply trying to create a means that is more efficient going forward because these projects are unrelated. And as has been stated repeatedly over the record, there's no coordination or connection between the two properties. And honestly, in fact, if things do proceed the way, it was just discussed, where, the Pi'ihana project does move toward a reversion of some type, I think it would only help to clarify for the record that, there was no connection to that process with the Wailuku Project District. That's, I guess, the first thing I wanted to say and make sure that that was very clear. The other thing I wanted to point out was that in terms of whether the Kealani Community Association has actually supported this bifurcation, I think it was suggested earlier that maybe that wasn't the case, but we have filed things previously early on in this process to establish the fact that the Kealani Community Association Board was informed and did pass a motion to support the bifurcation process. So that association is, supportive of this objective. And I think I'll stop there. I just wanted to be sure that that was very clear for the commissioners.
Mahalo, Mr. Sakamoto. Commissioners, questions? Commissioner Okuda, followed by Commissioner Chang.
Thank you very much, Mr. Chair. Mr. Sakamoto, is today the first time you heard of the possible intention of the other project district to revert themselves back to agriculture?
It was the first time I've heard it stated definitively like that. I have seen an email that Mr. Lindsay sent to the County of Maui a while ago, and it was just an inquiry asking the county for comments. It wasn't a declaration that this was a fait accompli. It wasn't a declaration that he had made up his mind to do it. I think he emailed the county saying that he's considering it and he wanted to know what their comments were. And beyond that, I don't know anything. I don't know anything else.
Okay. My other question is, you heard the public witnesses' testimonies about why they opposed the bifurcation in a way that they described it. There's allegations that certain improvements promised weren't made. Do you have any response to that, the public testimony?
I don't have any, specific point-by-point responses, Commissioner Okuda, except to say that, my client has been very diligent about filing annual reports with this commission, copying the County of Maui every single year since it acquired this property in 2012 or 2013. And, it's been very clear about the status of what has been done and what is yet to be done. And, I think that, as far as I know, and the county, I guess, secondly, I guess, with respect to some of the specific issues that the county feels may not yet have been done, we had a very, I think, detailed discussion with the county between the last hearing and this hearing. Our response, in fact, is attached as an exhibit to the county's filing, because we responded to their questions in writing as far as where we stood on these issues. Lastly, as it relates to the community center or the site for the community center, I heard several of the public testifiers bring that issue up. I think the best I could say now is, and I don't mean to be elusive about this, it's being handled by another attorney, not myself, but there have been discussions directly with the county, which involved the community center. And a proposal was presented to the county, I think in October. To my knowledge, we don't have a formal response to that proposal. So, that's the best I can tell you at this juncture.
Okay, well, let's just focus in on the community center. And by the way, we take into account all public testimony, but I do recognize the fact, and we all know this from all the trial work you and I have done over the years, that sometimes, a snapshot of witness testimony may not give you the whole picture. But, given the fact that there's been testimony about the community center, let me ask you this. In the history of the project, your section of the DNO, was there representations of a community center as an amenity that was being presented to potential owners along the lines like, hey, by the way, if you buy in and buy a piece of property or buy a lot here or buy a interest in a condominium unit, you'll have the benefit of this community center?
You're asking me if during my involvement with this, whether my client made that representation to potential buyers that there would be a community center?
Oh no, let me just ask it more precisely. At least one of the witnesses seemed to testify that the representation or the promise of a community center was a material fact that was taken into account by that person to buy into the project. Was that accurate testimony as far as what the facts were as you know them to be, even if your knowledge might be second or third hand?
I guess I can say this. It is true that there is a reference to a community center in the findings of fact, the 1990 DNO findings of fact. That much is clear. It is not a condition of the DNO to provide a community center. So essentially what I think, as I understand the argument being made, is that because there was a reference to a community center in the findings of fact, that although it is not stated as an express condition of the DNO, they are relying upon a condition in the DNO. It's the standard LUC condition that says the property shall be developed in substantial compliance with the representations made to the commission. So weaving those two things together, I think the argument is that it has thereby become a requirement. I don't want to put words in people's mouths, but that is my understanding of how this issue has come up.
Okay. My final question is basically this. If for some reason the commission were to decide either to deny this bifurcation at this point in time or defer action on the stipulation because of what has suddenly transpired during this hearing, is there any real prejudice to your client if you took that period of time of a deferral or where, whatever break there is in getting this kind of stipulation approved by the commission, if you took that time to talk to these community people to see if you could get their input and maybe see if something can be worked out? Is there any prejudice to doing that to your client right now?
I don't know that I could point to specific prejudice other than the fact that it would, like I said, that this problem with the clouding of the title will not be resolved. It will remain, as we go forward. I think the other thing is that the way the DNO conditions read is, and I'm paraphrasing here, but the petitioners were basically obliged to work with the county Department of Parks on satisfying park dedication requirements. And that is what I think has been going on over the years. And in other words, we need to be sure that the county has accepted, the park dedication and that we've satisfied that condition, as far as the county is concerned, there isn't a condition that says go out and canvass the homeowners and see what they want. So I guess it's a long way of saying, I don't want to create confusion about what can be done, what should be done, who has the final say, on an issue like this.
Okay.
Yeah.
But as far as specific prejudice that can be pointed to either by a deferral of this matter or by a denial with leave that you can go and refile another stipulation or refile an appropriate motion. Would it be a fair statement to say that right now anyway, you can't really point to a specific piece of prejudice except for possibly the ongoing prejudice by what you call the clouding of title? Would that be a fair statement?
Yes, but if you would allow me to just be sure it's clear, the refiling of a motion is not as simple as it would sometimes otherwise be because, well, first of all, the project, Wailuku Project District really does not have any feasible way to bring a motion. As I understand it from working with the LUC staff, we would have had to obtain 2,000 signatures to authorize us to bring the motion for bifurcation, because that's how many people have already purchased lots, which is not a practicable means of proceeding. On the other hand, the Pi'ihana Project District, which at the time we started this had, I believe, 6 owners or 7, did have the practical ability to get everybody that had an interest in the Pi'ihana District to authorize a motion. And essentially what we were obliged to do was to make sure that the 2,000 owners on our side were served with that motion, so they were given proper notice. And that is in fact what happened. Now, if there's a deferral and this process goes on for some indefinite period of time, especially if the Pi'ihana District continues to sell lots and this group of 6 keeps changing, the refiling and the reauthorization of Mr. McFarland as the attorney for the various owners, it becomes logistically more complicated and more difficult. So to bring it back to this point where we are now is not going to be that easy. I mean, frankly, it may be impossible, because if some of the owners decide that they don't want to join in at Pi'ihana, I don't know what happens at that point.
Okay, but right now anyway, if, for example, there was just a deferral, let's say not just a denial of the stipulation and the motion, but if there was a deferral, your client would not suffer that procedural prejudice which you described, or at least not to the extent where you've got to get authorization from 1,000, possibly 1,000 owners, correct?
Yeah, as long as it's not an indefinite deferral. And, I think that other than what I disclosed, that's what I would say would be the impact on us.
Okay, and my final question deals with this prejudice of a cloud on title. At the time that your client was making sales of the individual properties, it had a duty to disclose material facts with respect to the sale, correct?
I think that's a fair statement.
Yeah, because there's not only a statute that deals with required disclosures in real estate transactions or residential real estate transactions, but there are those cases, the Schaefer versus Earl Thacker disclosure cases. Now, if in fact this, as you described it, cloud on title is such a problem, wouldn't that fact have been disclosed to the buyers so they would be aware that if they're buying into your client's project, that's what the purchase comes with, the underlying land use commission order, with all its benefits, but all its responsibilities?
Yeah, I've not been involved with any sales, so I can't tell you what they did or didn't do. I do know that the conditions of the DNO were put of record as required by the DNO. There's a declaration of conditions that has been recorded in the Bureau of Conveyances. So anybody who acquires title to a property in the Wailuku Project District does see that the title is encumbered by that declaration.
Okay, so in other words, all buyers were on notice that part of the deal in purchasing their properties was the fact that it comes along with this land use commission decision and order, correct?
I mean, I think that there was constructive notice to that
Okay.
effect.
Okay, Mr. Chair, thank you very much. I have no further questions. Thank you, Mr. Sakamoto.
Thank you very much, Commissioner Okuda. We will have Commissioner Chang, followed by Ohigashi, followed by Cabral.
Thank you, Mr. Chair. Good morning, Mr. Sakamoto. Thank you for being here this morning. I just wanted to, in light of Mr. McFarland's disclosure regarding Mr. Lindsay's potential decision to seek a reversion, does that in any way change your client's position on the stipulation?
Oh my.
I don't think so. I mean, I think that the idea behind the stipulation was to allow both properties to proceed on independent paths. And, that was basically why we started this process. And whatever the fate of the Pi'ihana Project District is, it is. And, I think that as far as we're concerned, the stipulation, the objective of the stipulation is still something we'd like to achieve.
Okay, I appreciate that. Could you, I'm trying to understand if there is a bifurcation. Well, let me back up. Currently, both parties, your client and Mr. McFarland's clients, are responsible to fulfill the obligations under the LUC's DNO. Would you agree with that? That they are jointly and responsibly responsible for fulfilling those obligations.
I don't know that I agree with that, Commissioner Chang. I mean, I think that, we have always been responsible for the Wailuku Project District, the conditions as they apply to Wailuku Project District. There's never been any sense that we were also obliged to perform the conditions as they apply to an unrelated property. I mean, there's no feasible means of doing that. It's really hard to imagine a scenario where that could actually even be done.
Because that was sort of my understanding at the last hearing, that LUC wanted a clarification from the parties, who's responsible for what obligations. And I know that you attempted to do that with the stipulation, but in the absence of the stipulation, if there is a reversion or a petition to revert the property, some of these infrastructure obligations where it is not really clear which party is responsible, that there is an argument that both parties may be responsible for some of these infrastructure requirements under the DNO, that if there is a bifurcation or if that at this, because there's sort of a lack of clarity, at least in my mind, on some of these infrastructure requirements, that currently both parties would be responsible for some of those obligations.
I'm sorry.
Okay, yeah, it probably was more of a statement than a question, but that in the absence of the bifurcation, that there's an argument with, and you may disagree, an argument that both parties are responsible for the obligations under the DNO. Would you agree?
I suppose you could make an argument. I don't agree with that argument. I don't see how that is possible for, you know, one developer to go and fulfill obligations on someone else's property that they have no right to be on or do anything with respect to. So other than an argument, I don't know that I agree that there's anything more than that.
But okay, so just kind of humor me, but in the absence, if we bifurcated the docket and we clearly separated, would you agree that the Land Use Commission and the public would not have the ability to hold both parties responsible to fulfill all of the obligations under the DNO? That if we bifurcated and there is an argument that both parties are responsible, but once we bifurcated, we are essentially separating the obligations of both parties.
That's the objective,
That's
you
the
know,
objective,
the bifurcation. Right? And we think it's important to be clear. I mean, this goes to the very point about the clouding of title, which is there is a question, there is an ambiguity which we would like to resolve. And it is for the benefit from our standpoint of all the people who have bought properties. We want to remove that ambiguity, you know, from their title. And we don't think that there really is as a practical matter, any real change. I mean, my client would have no ability to go and do anything as it relates to the Pi'ihana property. They don't have an interest in it. They don't have the right to even enter the property. They don't have any business with respect to that property. So I don't know how not having that right later is any different from the status as it currently exists. We don't have the right to even do that now.
But you would agree that the benefit is really to your clients. At this point in time, the clearing of the cloud is to the benefit of your clients. That
it is clearly, oh, I'm sorry.
No, I'm sorry, yes. So that if we don't bifurcate this case, and there is an argument, because I would agree that with respect to those conditions that apply strictly to activities on the Pi'ihana project, that's the Pi'ihana's, that's those petitioners' obligations. But I am more concerned about the infrastructure requirements, the roadways, and perhaps Commissioner Giovanni will talk more about the bridge. But those kinds of major infrastructure requirements that were placed on the LUC conditions, where there is an argument that to a certain extent, both parties are obligated to fulfill those conditions, that if we bifurcated this, that we would no longer be able to hold, when you, pursuant to your stipulation, those things that you say are the sole obligations of Pi'ihana would no longer be, the commission would not be able to go and ask your clients to fulfill those obligations. I know I made that kind of confusing. Well, let me go on. Let me just ask you one final question. There are outstanding dedications that Wailuku, your clients have to fulfill. Is that correct?
Yes, that is correct. There are still certain things which need to be done. And I think, as I mentioned earlier, we've had very clear discussions with the county about what they are. And it's laid out in one of our letters to the county on what the status of each of those things is.
Is there a cost estimate to those dedications, the value?
Yes, I think we provided that.
Is that the one about the $5.6 million?
You know, I don't have it in front of me right now, but I can find out what those numbers are.
Is there an agreement with the county as to what those requirements are?
I don't know that we've reached an agreement with the county. I think that we've had discussions with the county. I think that, you know, those discussions are ongoing and will continue, you know, even after the bifurcation. But I think it's you know, it's not something that we're hiding from or running from. I think we're trying to lay it out on the table so that we have a meeting of the minds as to what is left and how much it will cost.
And I'm not too sure if we've got the authority to do this, but my question to you is, would your client be willing to post a bond for the value of those dedications to ensure, as you say, that they will be fulfilled?
I can't answer that without conferring with my client. I mean, I can't make that commitment on their behalf. I believe, Commissioner Chang, that if you look at the historical performance of what has been done to date, what they have completed versus the very, I think, relatively small amount that is yet to be done. Frankly, I don't believe a bond would be necessary, or I don't think the cost would be justifiable, because, you know, the bond will come with a cost. But like I said, I can't make any commitment for my client without having a discussion with them on that point.
And I appreciate your comment on that. I guess it's just that we, you know, in a lot of, not only this project, but other projects, the public will come forward to us and say that these conditions have not been met. And then there's a foreclosure or there's a bankruptcy and they never get met. So I know in the future, I will want to perhaps include as a condition a placement of a bond for to ensure that these kinds of conditions are met, because in the absence of that, there's no guarantee that the public who will get the benefit of those conditions. So, okay, I understand your position. Thank you so much. I have no further questions.
Thank you, Commissioner Chang. We have Commissioner Ohigashi followed by Commissioner Cabral. I'm noting it is noon. All hopes for a quick meeting this morning have completely evaporated. I'm sure to everyone's dismay, every participant. What I'm going to suggest is we go with questions for Mr. Sakamoto from Commissioner Ohigashi and Commissioner Cabral, and then we go into a lunchtime recess and resume after lunch. Commissioner Ohigashi.
Mr. Sakamoto, one thing I miss about Zoom is not having your nameplate in front of me. But what I wanted to know was, I'm looking at the County of Maui's filing, and then looking on page 4, and looking at your filings, the stipulation, it says 80, finding in fact 85, that's going to come under you, under your client. Is that right? The petitioner proposed to develop and dedicate approximately 110 acres of parks and open space, as well as a community center within the Wailuku project district.
Yes.
All right. And then in the condition or the conclusion, I think, or the condition that you refer to, petitioner shall develop the property in substantial compliance with the representations made to the Land Use Commission and obtain the reclassification of property. That is coming under both of you. So those two are, and further down, it refers to a letter that was sent that required by your client, indicating that the RCFC shall petition the State Land Use Commission to determine whether the requirements of finding of fact 85 required to construct a community center. So is that part of the stipulation?
The stipulation that we submitted, or is
Yes.
that your question? No.
So in order for, so we may or may not receive that motion. Is that what you're telling me under the stipulation? Because I think the stipulation sits for 6 months and whether for both parties to provide that. I was wondering if that would be included in that 6-month period.
No, I mean, the stipulation that we signed says within 6 months of the date of the order, RCFC shall file with the commission a statement of current costs for the remaining Wailuku Project District development and outstanding improvements, as well as a detailed schedule for necessary approvals and development.
So,
and that's basically it.
So that does not include this petition that you have indicated in the.
No, it does not. I mean, and I guess, Commissioner Higashi, you know, the one thing I can say is, and I think you're looking at the County of Maui statement. I don't want to speak for them because they're well represented here, which they filed on December 1st. I would only ask that you consider the fact that the stipulation was actually filed with the commission on December 8th, you know, after they made their position statement. They still signed a stipulation saying basically what they were expecting from my client was the matters that I just read off.
I understand that, but what I'm just trying to figure out is, because this was placed here December 1st, was it contemplated to be one of the things that will be filed within 6 months in the stipulation that's been filed on December 8th?
Yeah, I don't mean to try to be elusive. I'm trying to find the best way of answering this. There is a proposal that was made, as I mentioned earlier, to address this community center issue. And that proposal was submitted by another attorney on behalf of RCFC Kehalani to the County of Maui back in October. As far as I know, from checking with him yesterday, we're still awaiting a response. So I don't want to say that there will be something coming within 6 months on that matter, if in fact it's resolved separately with the county pursuant to that proposal.
So because I'm just kind of, so will we know about this so-called agreement that you have? Because it does involve, it seems to me it does involve a condition that specifically outlines 110 acres. And I think that the submittals that was sent was 27 acres were so far dedicated for parks. So I'm just wondering, 2 counts, so 110 acres in the community center, are those things be brought to us by your client as issues in here? Because as far as I can tell, is kind of like 90-something acres short of the 110.
I guess after the bifurcation, you know, we will respond to any inquiry that the commission has. I mean, on this or any other matter. It's a complicated discussion. Let me put it that way. And one of the reasons why I didn't file anything in response to the county's papers was that, well, first of all, we had the stipulation that was signed. But secondly, you know, I don't think it's necessarily tied to the bifurcation. You know, if it's, like I said, if it's an issue prior to the bifurcation, it's still going to be an issue after the bifurcation. The bifurcation doesn't make anything disappear.
Well, I was just asking in the context of the stipulation. there was a statement made in there, in their filing, and to be honest, the stipulation could have included, it was broad enough to include that issue to be brought before the LUC, and I was wondering if that was, and if not, are we going to be involved in it? And the last thing the last thing you maybe can answer for me is that when they say petition the commission, don't you run into the same problems of getting all 2,000 someone's signatures? I'm just asking.
Yeah,
you don't have to answer the last one. I don't know.
I don't know how to answer that. I mean, I think that you know, if we had to get every person's signature, every owner's signature for every document we filed with the commission, that would be impracticable. But I think that when it comes to clarifying developer obligations, I think that that's something which, you know, we can do directly and without all of that backup. I think the difference here is that what we're seeking to achieve with the bifurcation is not a developer obligation per se. We're really trying to clear up the title for all the homeowners and the various people that own these properties. That's why I think this thing about needing the signatures from everybody, because it affected so many people's title, was where the line was drawn.
I only asked the question because there was those requirements in there as part of the situation. So I look forward to hearing about the 110 and community center issues. No further questions.
Commissioner, thank you, Commissioner Ohigashi. Commissioner Cabral. You're muted.
Yes,
There
thank
you
you.
go.
Thank you, Chairman Schroyer and Mr. Sakamoto. Thank you for being here and trying to help us clarify this. I'm clearly more confused than I was when we opened this meeting. So you are agreeing, did I hear you correct, that you said that you understand your client and your part of that development does have that obligation to make sure that there is 110 acres of open space dedicated? Is that something you've indicated, of which you've dedicated 27 acres so far? Did I hear that correctly?
I don't know if I said that. I think we acknowledged that certain findings of fact are attributable to certain projects. And 85, I think it says it in the stipulation, is one that's attributable to Wailuku Project District. With respect to the satisfaction of park dedication, it's a much more complicated question. And you know, I don't know that I'm prepared to discuss all of it right now. I will do my best if you want to hear it, but I think that, you know, our position is that as it relates to conditions and performance, we've been working very closely since my client acquired an interest in this property in 2012. With the county, with the Parks Department, and you know, I think that we've been doing what we were expected to do. I'm not saying that it's done, but I think that we have been performing in good faith up till now.
Okay, well, I know everyone's ready for the lunch break. So, and I thank my fellow commissioners. I'm going in that same direction of, I want to figure out who's going to do what in what kind of time frame and make that commitment so that if there were to be a bifurcation in the future, that you would clearly know your clients are obligated to do a certain number of things. And we would want to know that they're going to get done in a timely manner. We're already 30 years into this, so it's a little, I don't want to leave it for somebody else in another 30 years. So, because I think the public is the one who in many ways has been suffering, and clearly that is your clients have been the ones that have suffered from this confusion. So I'll save any other questions to the future, and hopefully we'll have more light on this subject as we move forward. Thank you.
Can I get a sense from my fellow commissioners how many more questions there might be for Mr. Sakamoto after we return from break? I have intention to ask Mr. Sakamoto about findings of fact 23 and sequential regarding affordable housing allocation between the two project districts, and what obligations might continue to apply to both parties equally. It is 12:12. I'm going to recommend that we take, how long do folks want? Half hour or 45 minutes? Arnold?
45, Chair. I need to eat, I have a big lunch.
This is why I asked you, Commissioner Wong. We will reconvene at 1 o'clock. I hope everybody has a good and peaceful lunch. And we will reconvene at 1 o'clock for continuing questioning of Mr. Sakamoto. We're in recess. Confirming we have received Mr. Buika's written testimony via email, resubmitted.
Sorry, Mr. Chair, I will go check.
No. We have received it. Scott has sent it.
Oh, okay.
Confirming. Statement rather than question, Mr. Hokoda, sorry.
Chair, sorry, can I make a comment?
You're not on the record yet, yeah.
Okay, yeah. Well, at any time during this break, I did read the 2 letters that the public submitted that Scott sent on to us by email, and I did read both of those during the break, and I wanted to definitely, even when we're on the record, thank them for submitting them. They were very well written, very clear, and very much to the point of what our current discussion is. So I wanted to thank them for that, their efforts.
I'll ask you to do that again when we're on the record.
Okay.
Commissioner Chang, Maui County, Mr. Hopper. Okay. Okay, people have moved. I see Mr. McFarland. You were on my right side of my screen before. You're now on my left, but I see you there. I think we have everybody. Commissioner Wong, Okuda, yeah, okay. So it's 1 o'clock. We are back on the record. Aloha, everyone. Commissioner Cabral, you want to state something on the record?
Yes, thank you, Chair. I wanted to let those, if they're still out there in the public area, know that we did receive earlier in after our meeting had started, we received the 2 different letters from Livet and Karen, K-A-R-I-N, that we received those, and I read those during the break, and they're very well written, and I really appreciate their willingness to submit those and put that time into it. And it's their comments were very much on point to our current conversation. So thank them very much for that effort.
And noting for the record that Mr. Buika's resubmitted testimony has been received by the commissioners.
Okay, I didn't see that one yet, but I'll get to it. Thank you.
Okay, so we're on questions by the commissioners for Mr. Sakamoto. Were there further questions for Mr. Sakamoto at this time, commissioners? If not, I have a few. And I indicated before the break, Mr. Sakamoto, that I want to ask you questions regarding affordable housing. How many units at full build out of your client's area, petition area, have been built?
How many units at full build out?
Yeah, because you have 3 more, right? If I understand.
Yeah. I don't have the answer off the top of my head, Chair, and I don't want to speculate, but it's something we can provide.
So if I understand the original docket correctly, there were originally going to be 2,400 units developed in the Pi'ilani project area and 600 units in the Pihana project area. Do I have that correct?
It sounds, yes, generally
Okay.
consistent with what I recall reading in the docket.
Okay, and then on finding of fact, starting at finding of fact 23 of the original decision in order, it notes that the petitioner proposed putting 100% of the units in the Pi'ihana project district would help fulfill affordable housing requirements, and 37.5% of the affordable units required would be built of the total units built in the Pi'ilani project area. And then it goes on to note that at least two agencies, the county and the Hawaii Housing Finance and Development Corporation, I believe, indicated that they wanted a more even split in affordable housing between the two areas. But the developer said, due to, and I believe this is finding of fact 24, petitioner explains that their proposed affordable housing allocation and distribution as a result of both the increase in state affordable housing requirements and the physiographic characteristics of the project districts, which I take to mean it was cheaper and easier to first develop the Pi'ilani project area, and that income from that was then going to be used to finance the development of the affordable housing and the Pi'ihana project area. Do you believe that statement is supported by the record, Mr. Sakamoto?
Well, first, let me clarify something. When you say Pi'ilani, are you referring to the Kehalani? You said Pi'ilani and Pi'ihana, but I just want to make sure I understand what you're
So,
asking me.
There's two project districts, correct?
Correct. Wailuku and Pi'ihana.
Okay, excuse me. So the Wailuku project rather than the Pi'ilani. So the development of the Wailuku project district was essentially going to fund the development of the affordable housing in the Pi'ihana project district due to the physiographic characteristics of the two districts.
I can only speculate. I'm not sure what the commission intended when they entered this finding of fact.
Well, so there's a series of findings of fact, and finding of fact 27, petitioner commits to continue working with the HFDC and the County of Maui to resolve the differences over the allocation and distribution of affordable housing units to be provided to be mutually agreeable between the petitioner, the HFDC, and the County of Maui. Have I stated that correctly?
Yes.
So where does your proposed bifurcation leave this condition?
The proposed bifurcation, I guess, first of all, this is a finding of fact, right? Not a condition.
So where does this leave? It is a condition in the sense of condition 10 that the petitioner agreed to abide by all of their representations. And this is obviously a key representation made by the petitioner. So where does your proposed bifurcation leave this, I believe, still pending, very significant allocation of affordable housing units to the Pi'ihana project district?
27 was applicable to both. Finding of fact 27, I guess we agreed would be applicable to both projects.
So what I'm really looking for, and I realize on the one hand, you've sat in our seat before and you've dealt with these issues. On the other hand, you're representing a client, but we're sitting in these seats now. And my concern is the LUC approved a docket with two project districts and tied knowingly certain conditions to both of them. And I believe, And I haven't delved into the actual transcripts, but I believe it's because they recognized the second area was harder to develop. They were going to use some of the profits from the first area to develop the second area, fulfill their affordable housing requirements. Now, if we separate them, and it appears based on the record that there is no financial ability nor intent of the current owner of the PE Hana project district, who was sold the land by your client, to fulfill any of these conditions. So we, the people of Hawaii, the people of Maui, are out 600 units of affordable housing. And I don't want to be out 600 units of affordable housing, especially because, right, we're about to enter the 4 months of the year where the LUC is ritualistically beaten as being the cause of Hawaii's affordable housing crisis. I don't enjoy it. So how in this docket do we move forward with all the stated things that both Mr. McFarland's clients and your clients need, but also fulfill the original intent that allowed this former agricultural land to be moved into the urban district? Because in return, we were getting affordable housing.
Yeah,
What's our
I
path
think
forward?
I don't think that there's any intention to not continue with the affordable housing performance. I guess the question is, what is the performance that is actually being required? And, you know, I did point out in the document I filed back in October that after the property was, after the boundary amendment was approved in 1990, then the county approved a rezoning of the Wailuku Project District 3. And in there, I pointed out that they were cognizant of this requirement to provide, you know, these basically 60% affordable units, which is a significantly high number. And you know, they acknowledge that. It says in the documents I filed, I'm looking at ordinance number 2053, Bill 70, 1991. It instructs the applicant to comply with the affordable housing requirements set forth in the LUC's decision and order dated January 30, 1990, and then proceeds to specify a lower income range for units. In other words, the range that was specified by the Land Use Commission was for 60% in the upper income ranges. But when the county took this condition, it applied them to even lower median income ranges, of which the total obligation from the county standpoint became 50% of the total units developed. So, you know, essentially, as I understand what happened at this point, the county was aware of what the LUC was requiring. The county made its own decision to adjust the requirements to apply to a lower income level, but the quid pro quo for that was the aggregate number of units went down from 60% to 50%. And so if you look at the ordinance that I attached to the document I filed, it provides the breakdown of a significantly lower median income level and how that's allocated to add up to 50% as it applies solely to the Wailuku Project District.
Yeah, but I guess what I'm trying to get to is that at the original docket, they were tied together. These two project
Yes.
districts, and the affordable housing projects were not really divisible. So if we are to have any hope of seeing the promised affordable housing units in the PE Hana project district developed, what's our path forward?
I don't know that I have an answer to that. I mean,
Was
I
your
can only
client
answer
paid for the purchase of the PE Hana lands?
Okay, so let me just make sure that this is clear too. The client I'm representing in this docket is RCFC Kehalani LLC. There was a separate entity who acquired an interest in the Pihana project, RCFC Pihana, okay, that basically acquired some interest through, I believe, a foreclosure process as well. They're not the same company, although I think that they're related interest in it because they were acquired probably by a lender through a foreclosure. So if you're asking me, was RCFC Kehalani paid for that? I mean, the answer is no. What was RCFC Pihana? I don't have any idea about what that transaction involved, to be honest with you. I was not involved in that.
It's not owned by the same parent company. They were not owned by the same parent company.
I can speculate that there was a commonality of interest. I don't know who the ultimate owners were. I think that they were acquired, as I said, by a lender.
So then I guess back to my previous question, what is right now in the docket in the decision and order, the affordable housing requirement fulfillment were tied together. What is our path forward? Is there a path forward?
I can only answer for the Wailuku Project District, Chair, and and the path forward in my mind is we will continue to do what we can do as it relates to the Wailuku Project District. And I think we've been reporting the progress. The history of this is before the lender foreclosed, my client inquired with the County of Maui Department of Housing and Human Concerns about what was the status of the satisfaction of these affordable housing requirements. And they did receive, a letter from the county which identified what the status was. And since that time, they've been reporting annually to the county and getting confirmation letters as to, what their status is. Are they compliant? Have they earned credits? And, I guess there's no intention to stop doing that and to satisfy the county's requirement of 50% in these income ranges. But I can't say anything more than that. I mean, if you're asking me to say something about how the Pihana obligations will be satisfied somehow by KLN, I can't say they will. I can't say that there's any way to do it.
I have nothing further. Commissioner Okuda.
Thank you, Mr. Chair. Mr. Sakamoto, I just have a question just so that we're clear about the effect of a foreclosure. A foreclosure is where the bank basically sells the collateral, in this case, real property. Is that correct?
You're asking me if that's generally what a foreclosure is? Yes. I mean, it's a sale by the court of the bank's collateral, right?
Right. And I'm asking stuff, even though, my law firm, my partners do a lot of foreclosures. So it's either a sale by the court, or it could be what we call a non-judicial foreclosure sale. But in any event, it's where the collateral is sold to somebody else, essentially after an auction, correct?
Yeah, this was done as a deed in lieu, just so that it's clear.
Okay. Yeah. A deed in lieu is where the bank or the lender takes the property in exchange for satisfaction of the obligation, correct?
Right.
But whether it's a foreclosure where there's an auction, either a judicial auction or a non-judicial auction, or a deed in lieu, the bottom line is the new owner of the property steps into the shoes, as we would say, of the prior owner, correct?
Correct.
So in other words, whatever obligations the prior owner had, for example, under a land use commission order, including, the affordable housing requirements, which the chair had, had this colloquy with you, whatever those obligations are, the foreclosure doesn't cut off those obligations, correct?
Right.
and whomever takes a deed in lieu is either knows or should know that fact that you take a deed in lieu. If you're a successor entitled to somebody who took a deed in lieu of a foreclosure, you will be subject to essentially assuming the underlying obligations of encumbrances and orders which run with the land, like the Land Use Commission order, correct?
Correct.
Okay, I just wanted to make sure we all understood that. Thank you very much, Mr. Sakamoto. Thank you, Mr. Chair. No further questions.
Thank you, Commissioner Okuda. Commissioner Chang.
Thank you, Mr. Chair. Mr. Sakamoto, during the line of questioning with the chair, you said you represented KCFC Kehalani. Is that correct?
RCFC.
RC, I see, RC. And you do not represent, there's another entity. What was the other entity you mentioned?
The other entity is RCFCPE HANA.
So do we have all the parties to the original docket participating in this stipulation?
You're saying as it relates to the Kehalani or Wailuku Project District?
No, yeah, as it relates to docket number A89-642, are all of the relevant parties through whatever subsequent transactions to this docket, are they part of this stipulation?
To my knowledge, yes.
Okay. So the RCFC PE HANA, they're not affiliated, they're not associated with this docket because you say you don't represent them.
No, I guess if they were still owning an interest in the PE HANA project, they might be part of the docket, but they do not have any interest in the PE HANA project district.
So, okay, bear with my ignorance on this, so because I'm so confused. So the RCFCP HANA, they were part of the original docket.
The original.
The
I'm
original.
not following you.
Oh yeah, no, I'm trying to make sure because if we're trying to determine whether this bifurcation, I'm trying to determine whether this matter before us has all of the relevant parties so that we can hold them responsible for those DNO obligations. You represent RCFC Kehalani.
Yes.
Ms. McFarland represents the Wailuku plantations. Now, you also mentioned RCFC PE HANA. They no longer have any interests in this in the original on this docket number?
No.
Okay. And did they ever have an interest in this docket number?
I believe they owned some of the property at some point, but have sold it.
And they sold it to who? Who represents the properties that they sold?
I don't know who all of them are, but I at least some of it, I believe, was sold to Wailuku Plantation.
So any obligations that RCFC PE HANA may have had under this original docket, who assumes those obligations when they sold? Does that make sense? Am I making sense to you? Because they were originally responsible as part of, they were originally part of the boundary amendment, correct?
The original party was BREWER.
Okay, yes.
Yes, and then it went through, I'm not sure how many changes of ownership during that time. Each party, as Commissioner Okuda pointed out, probably acquired title that was encumbered by these conditions. You know, so I think the conditions ran with the land. And then you know, the parties that are part of this docket now that are in front of you that signed the stipulation are, to my knowledge, the parties who collectively represent all the owners.
Okay, so as you indicate, the obligations run with the land. So when RCFCP HANA sold their properties, they also included the obligations. So is it your understanding that Wailuku Plantations assumes those responsibilities, those obligations?
Yes.
And none of your, and you don't represent any properties that were originally owned under RCFCP HANA?
No.
Okay. All right, sorry, I'm just confused. This docket has so many transactions. Okay, thank you very much.
I guess if I may, following up on Commissioner Chang, RCFC Pihana and RCFC Kehalani, were they owned by the same parent company?
I don't know, honestly, who the owner of the parent company is. And my contact on this matter is through my client in Maui, who owns the company. Ultimately, I don't know.
So they may be owned by they may have been owned by the same company.
There may have been some, I mean, RCFC, the fact that RCFC is in both names, I would assume that there is a commonality of interest.
That's my assumption. So it's possible that really, if the same entity owned both, they really got a twofer on the transaction. First, they got paid for the land, and then they got to foist a whole bunch of obligations onto the new owner, the unsuspecting new owner.
Well, I think that like any real estate transaction, you buy the benefit and the burden, and I think that's part of any real estate transaction. You know, that's reflected in the price. So I don't know that there was any foisting of anything.
Fair enough. Is there anything further from Mr. Sakamoto? If not, I think we will now hear from Maui County and Mr. Hopper.
Thank you, Mr. Chair. Can you hear me okay?
We can hear you. Thank you very much for checking.
The County of Maui has signed the stipulation in support of the motion for bifurcation. As you may recall, this docket's been, well, the docket itself has been going on for 30 years, but this particular proceeding regarding Pi'ihana, the issues, the compliance issues there, and the issue of bifurcation has been going on for several years now. And the county initially,
Excuse me, Mr. Hopper. I'm so
Yes.
sorry to interrupt. This is Jean, the court reporter. Can you speak a little louder for me, please? And possibly
Okay, I'll do my
slower.
best. The computer
Thank you.
audio is a bit off to the side and this is new, so I'll talk louder and absolutely let me know if I'm not loud enough.
Thank you.
The County of Maui, as you may recall, did initially have concerns with the bifurcation. The original motion and this motion in particular originally did not have any conditions, stipulations whatsoever that would involve clearly allocating the responsibilities of the findings of fact, conclusions of law, and decision in order to the parties, and also did not have any requirements dealing with the ongoing compliance issues in both the Kehalani and Pi'ihana project districts. However, the county, after reviewing the decision in order, or the proposed decision in order and the stipulation, is amenable to the bifurcation, provided that there is a clear allocation of obligations among the parties, and that the parties within a certain period of time after the bifurcation are required to indicate compliance with the conditions and representations made, and to the extent there are outstanding obligations, provide timetables for those developments. Now, the issue with not bifurcating in this case, and the county has reviewed this, is that you have discussed the issue of the owners of Kehalani being responsible for Pi'ihana and the owners of Pi'ihana being responsible for Kehalani. Jointly and severally, I think Commissioner Chang had brought that up. Now, one issue that may create is that the current homeowners in Kehalani would, by that logic, be responsible for compliance with the Pi'ihana Project District and for any breaches in the Pi'ihana Project District. And until bifurcation, would be responsible for fulfilling those conditions, technically. The practical difficulty and potentially legal difficulty with that is that obviously those homeowners and the successor owners in Kehalani don't have any ownership interest in the Pi'ihana Project District. And so therefore, if there was an enforcement action against Kehalani, for example, to require them to build in the Pi'ihana Project District or to otherwise come into compliance in Pi'ihana, the county would be asking, as the enforcement officer, would have to ask a court to order the Kehalani Project District, including the homeowners there, to effectuate an action on land it doesn't own. And if there was a way to prevent the ownership of the sale of the property in cases like this, or in other cases where it could be even more complicated, where the land is contiguous and it's not sort of easily separated, that could potentially prevent that issue from happening. But as long as under Hawaii law, we cannot prevent the sale of land to other parties, we have this potential issue of a decision and order being recorded on both of the properties, and an owner of the property not necessarily being able to effectuate compliance on another portion of the property. And so that was one of the concerns we had with the ongoing, without bifurcating some of the issues that we would potentially have. And I think why the county was okay with having the enforcement actions or the ongoing compliance discussions on both of these properties in separate dockets, with the understanding that there's not a reduction in the requirements to develop the project districts by bifurcating. I would note that in addition to the fact that there's record notice to the parties that the DNO has been recorded, condition 14 of the decision and order even states that the deeds in any sale have to specifically contain reference to the decision and order. So in any sale of the property, the deeds themselves have to reference the decision and order as an encumbrance on title. A couple of other issues I think we wanted to address that have been brought up by commissioners. One is in the decision and order, the discussion of affordable housing, and to what extent there are conditions, if any, and representations, if any, that can't really be separated out into different project districts, meaning that you can't bifurcate because there are really joint obligations in some of these cases. With respect to the affordable housing findings of fact, I think the planning department had reviewed that. There was a discussion of the original proposal, discussions by then the County of Maui, HHFDC, on the merits of that, but it resulted in condition number 1. Those findings in conclusion, the findings of fact resulted in a condition. And I think the findings of fact to a large extent do show the discussion, but the conclusion reached by the LUC, I think, was to come up with condition 1. And condition 1 states that petitioner shall provide housing opportunities for low, moderate, and moderate income residents of the state by offering for sale or lease a number of units equal to at least 30% of the residential units in each of the project districts on the property, and then provides an income range, and then states, and a number of units equal to at least 30% of the residential units in each of the project districts on the property, and then states another income range. There's other parts of that condition, and the county is looking into that condition and believes that should be an ongoing issue to look into after bifurcation, and therefore has required that as a condition to be provided within 6 months of the decision and order. The way that the county has read that condition is that each project district has to provide 30% of its units in one income range and 30% of its units in another income range, but that that the Kehalani district doesn't have to provide, that the units in Pi'ihana would not be used to fulfill that requirement for Kehalani and vice versa, that each has their own percentage requirements. Now, if the commission disagrees with that reading and believes that there's a joint requirement, then certainly we can look at that, and that would affect bifurcation. But the way that the county has read those conditions is that each project district independently has a percentage requirement in each district that represent a percentage of its units. And yes, there are findings of fact on this issue, but those were, I think, resulted in this decision, this condition number 1, which is the affordable housing requirement and what would apply. So that's how the county had read that issue. The other issue dealing with Pi'ihana and their decision apparently to seek reversion of the property. The county was, I did discuss with the department, it did receive an email from Mr. Lindsay, but it was, I think, as Mr. Sakamoto had represented, sort of a statement of we're not certain if we can comply. We would, reversion could be an option, but it was not seen as, I think, a formal request to revert the property, and would not alleviate the obligation if that was going to be something that they were going to take a formal position on, to file such a statement with the commission. We had planned at this hearing to give you the information that we had received, that that the Pi'ihani was had stated that it was concerned with its ability to fulfill the conditions and may have to revert the property. But from day one, since we've dealt with these compliance issues, the County of Maui has stated it does not believe that the Pi'ihana owners can develop this property in compliance with the decision and order, and has also raised issues such as the fact that there is at least one house with someone living in it on the property, which is a flagrant violation of the conditions. And now that house is owned by a different party, but there are for sure significant compliance issues with the Pi'ihana project district. And the county has, as a requirement of this, required that both a hearing on the outstanding obligations and specifically the financial capability of the Pi'ihana project district owners to fulfill the project be provided. The county believes, similar to the Kehalani obligations, that those can be addressed after bifurcation, because Pi'ihana will be its own docket and will be responsible for its own conditions. However, today is the first time we have seen in a formal capacity the council for the Pi'ihana project district state that it is their intention to file a petition to revert the property. I do not believe that necessarily changes our position on the bifurcation, because that reversion could potentially still happen after bifurcation. And to be honest, if it's not bifurcated, I'm unclear on whether that could be bifurcated, that could be reverted, because if the project districts are consolidated and they're owned by, and they're under a same docket, I think the issue of substantial commencement may come up, because if Kehalani is considered part of Pi'ihana, well, is that an issue of substantial commencement there that you'd have to deal with, where otherwise, if there was a bifurcation, you wouldn't. But certainly, this is ultimately up to the commission if it would want to grant bifurcation. At this stage, the county still believes that bifurcating based on the stipulated decision and order is the proper way to proceed in this docket, particularly because of the concerns of attempting to enforce, the obligations of Pi'ihana against Kehalani owners and the Kehalani project district and vice versa. And in addition, because if you read the decision in order, while we did need to specifically allocate the representations made to make sure that they're applicable to the appropriate parties, I think this original decision in order did envision the properties being developed as separate projects. In fact, there are a lot of the traffic conditions, for example, or the traffic findings of fact and conclusions of law are separated by Pi'ihana project district and Wailuku project district. And there's a statement of, here are the obligations for Pi'ihana, here are the obligations for Wailuku project district. And that's something the department did review, was whether or not there were joint obligations that that each party would have to fulfill. And with the allocation in the proposed order, we do believe that that's been addressed. Obviously, if the commission still has concerns with bifurcation, as the county did originally, that's something that you should, review and be comfortable with prior to bifurcation. But we wanted you to certainly understand the basis for the county's willingness to support bifurcation under these conditions versus the position before this was clarified that there was not sufficient clarity to support bifurcation. But we do certainly acknowledge there are significant compliance issues with Pi'ihana and with Kehalani. And I think the question for the commission is, can those still be addressed after bifurcation? And is that something it can still do? And the county does believe that that's something that can still be done after bifurcation and is most appropriately done in each separate docket. You can have a status conference for each of the dockets separately, rather than continuing to have status conferences with both of the parties here and have confusion as to who's responsible for which conditions. I think this provides that clarity and is appropriate action to take at this stage.
Is that it for now, Mr. Hopper? Is that it, Mr. Hopper, for now? Is that the
Yes.
conclusion of your statement? Thank you. Commissioner Wong, followed by Commissioner Okuda.
Thank you, Chair. Good afternoon, Mr. Hopper. First off, I just want to reconfirm, because I heard all these things and just want to make sure in my mind that the stipulation that is before you, is the county okay with it or not? Yes or no?
Yes. Yes.
Okay, so you heard Mr. McFarland stated about them coming back to revert to ag. Are you okay with that?
Well, we're not necessarily okay with them taking that action. We have from the beginning not believed that they would be able to successfully develop this project, but do believe that those compliance issues can be done through enforcement after bifurcation. We think the bifurcation is separate from Pi'ihana's ability to develop the project, because if they can't develop the project and it's not bifurcated, is Kehalani then on the hook for Pi'ihana's failure to develop that project? And are they therefore subject to enforcement actions for Pi'ihana's failure to comply with the conditions? That was part of our concern.
Okay, so the other thing is, as you know, in this hearing today, I think someone stated that LUC sets the conditions, findings of fact, and decision orders, and that it's up to the county to assist in ensuring that the conditions are met. Is that correct?
Yes, under HRS, enforcement of the conditions is the county's responsibility. Yes, that's correct.
Okay, so the other question I have is, we heard from Mr. McFarland or someone that there are houses and some other buildings that's movable on that area. Did the county know about this?
Yeah, the county is currently pursuing enforcement on those issues right now through various departments. There's significant issues, certainly.
Okay. I just wanted to make sure about these things. Thank you, Chair. Thank you, Mr. Hopper.
Okay, Commissioner Okuda. Thank you, Commissioner Wong. Commissioner Okuda, followed by Commissioner Ohigashi.
Mr. Hopper, thank you very much for your testimony and for the information you provided. Let me first follow up on what Commissioner Wong was asking and your response to his question. This deals with enforcement. The enforcement power, or the power to enforce the Land Use Commission's conditions, again, rests with the county, not with the Land Use Commission once there's substantial commencement of use of the property. Is that correct?
Yes, with the caveat that we would generally approach the commission and through declaratory rulings or other proceedings, get clarity, especially when we're talking about findings of fact on what was expected and what is required of the landowners. But yes, the enforcement through HRS is through the county.
And, not to prejudge anything that might take place or might not take place in the future, but I'm not aware of any appellate case or statute or legal authority which gives the Land Use Commission authority to command or compel you or any other planning department or county enforcement officer to actually take an enforcement action. Is that a fair statement of the state of the law as you understand it, that we at the Land Use Commission, we might make a lot of noise, but the bottom line is the discretion to enforce or not enforce, or to the extent of enforcement, that really rests with the county once there's substantial commencement of use of the property. Is that a fair statement?
I believe the Lanai Company case addressed this by the Hawaii Supreme Court, and I think their statement was something to the effect of, once the Land Use Commission has found a violation, it is the responsibility of the county to enforce. Now, I don't think that requires necessarily a finding by the commission of a violation before the county can enforce. And I would agree with you that the commission cannot compel enforcement by the county or by court order. I think that's what Lanai Company had helped to establish. But I think the point I'm trying to make is that because you've got 30 years of history, you've got a lengthy decision in order with findings of fact, is that we would rely on the Land Use Commission's view and decisions based on its own decisions in order in the enforcement process. That happened in the Pi'ilani Promenade case, where the county believed they were in compliance and the commission disagreed and said, no, county, we believe they are not in compliance. So for the future, the county has generally been of the view that we take things to the commission for LUC dockets and be very sure if there's a violation that there in fact is a violation, or if there's not, that there's not. So that's where we're at with that.
Yeah, and we, at least I definitely appreciate how you bring things to the commission, your clarity and not only clarity of presentation, but clarity of purpose. And maybe that's why I'm a lot more comfortable with how you folks handle enforcement. Let me ask a question along that line. Would you agree that because this type of enforcement action by the county is essentially an exercise of the police power, there really is a fair amount of discretion that's vested with the county on how it exercises its police power with respect to these types of issues?
Yes, there would be. I would also add if it would be okay, there are other laws, of course, other than the Land Use Commission decision in order that are at issue here and that the county is involved in enforcing. So when I say enforcement, it's not just LUC issues, but as you probably can tell from the description of what's happening there, there are a variety of other legal enforcement issues ongoing.
Yeah, and maybe, and I don't mean to belabor these questions, but my point to these questions, taking into account your response, is that when you get to the bottom line here, the county is not simply going to blindly follow a command which which the county, based on, of course, adequate legal research and consideration of the facts, would consider to be somehow abusive to the citizens of Maui. I know that's a fact-specific question, but like if we at the Land Use Commission, made these statements, which frankly you believe exceeded reasonable exercise of the police power of the county, you're not going to just blindly follow what we say, right? You would take appropriate action, correct?
I mean, I'd like specifics. I mean, if we asked for a declaratory ruling and the LUC gave one that we disagreed with, then we would have the option to appeal that to a court.
Yeah, right.
Or I guess we could just not follow it, but then that would sort of make it pointless to ask you in the first place.
Yeah.
So that's, I mean, I think we would generally respect the commission's view on an item. The other concern we have is that if we're the enforcement officer it would be the county personnel in court arguing these cases. And we would go before a judge and say, we want these Kehalani property owners to fix what's on the Pihana project district, and ask a judge to say, order these guys to fix issues on another property. That's part of our concern that I was getting at in an earlier statement.
Yeah, and that's the reason for my questions, because I don't believe I heard any of the commissioners, and I'm certainly not saying that the county should force an 85-year-old grandfather or grandmother to go and build a bridge which a developer had represented the bridge would be built, even if you can make a technical legal argument which might be technically correct. I mean, none of us are saying that. But I do agree with the chair's line of questionings that if there are representations made for specific amounts of affordable housing, for example, or other improvements that are represented, and it really appears from the record, that's the reason or some of the reasons why the original applicant, C. Brewer, was able to get the boundary amendment, then would you agree it's not unreasonable to hold the developer entities, whomever those developer entities may be, for whatever obligations they may be either jointly or severally obligated to? I'm not asking you to prejudge who in this case would be responsible, but as a general matter, it's not unreasonable to say, okay, we might not go after the 85-year-old kupuna to build a bridge, but we will certainly hold developer entities for the obligations that they definitely should have known with due diligence follow from a land use commission order. I mean, isn't that a reasonable position to take?
Well, I would say as a general matter, yes. But if you're talking about sales of the property, I'm not sure how seeing Pihana, how Kealani selling a portion of the property would have been different than, for example, them selling all of the property. If they sold the property with the decision and order on it that allows you to fulfill the conditions on that property that you own, do they have an impossibility of performance argument at that point? Do they sue Pihana and say, you've got to build the housing here? Or how is it different than if they had sold the whole property? And then I guess it's because they still own property with the decision and order recorded on it that says you're responsible for it still. But to make them fulfill building affordable housing on a property that it doesn't own, if the commission knows of case law or things that would state, yes, you still have to make them build it, then we'd be happy to look at that. But that was our concern with not bifurcating and keeping this thing out there was the nature of the project districts as described in the DNO and the current ownership structure of the property right now.
Yeah, and I don't mean to belabor this, but because I'm going to move on to another question right after this, and that would be my last couple questions. But the fact that a landowner or somebody who has an obligation gets rid of an asset doesn't necessarily absolve that person from obligations to perform on the obligations that they should have performed. In other words, for example, isn't it true that under the Uniform Fraudulent Conveyance Act, if you own a corporation, the corporation has obligations, and you intentionally don't perform the obligations, and you drain the corporation of its profits, there still might be, in fact, personal liability against corporate owners. I'm just saying that's a possibility, right? So sometimes the obligation not only runs with the land, but it might even follow when you get rid of the land. That's more a statement, Mr. Hopper, because the question is this: I'm thinking if there's no bifurcation, at least right now, or if there's a deferral, this actually gives the County of Maui more tools in its toolbox on whatever type of enforcement action the county wants to take. I'm not proposing that people be held hostage here, but sometimes if there's no quid pro quo back to the community, a clear community benefit, I've got this concern, and maybe you can address it. What is the community getting in return that people are going to be let off the hook for obligations which have been running on this land for decades?
I would want to know what obligations, because the county is very concerned about this and was. What obligations, if bifurcation is granted, will the developers be left off of the hook from? That is a grave concern of ours. We want to make sure that there are no obligations that someone's left off the hook from if this bifurcation happens. Well, we could not find any that would not still be enforceable against the appropriate parties after bifurcation. Kehalani's the community center issue, which we do have issues with, their affordable housing allocation, their parks allocations. Those are things that appear to still be Kehalani's obligations after bifurcation. I understand that technically, yeah, maybe the county could issue a notice of violation against Kehalani, the developer only, or the homeowners, but you're talking about the developer only, to fix the situation in Pi'ihana. I guess that's technically something the county could try. I don't know if it would be successful, but we did not see that concern as being a basis to justify continued opposition to bifurcation, given the conditions that were put in place and given the nature of the development of the property. It appeared that the bifurcation is appropriate in this situation to make the obligations of the parties clear and the obligations of the county clear with respect to who is responsible for what. But obviously, if the commission thinks that there are obligations that landowners will be left off the hook from, as you said, by bifurcating, then let's address those. Absolutely, that's important. But we did not see those in our in the review.
Okay, and my final question is this: if the Land Use Commission were to decide to defer this matter just for a reasonable period of time, and we can argue what reasonable means, but let's just use that term, would the county suffer any actual prejudice by a reasonable deferral, just so that we can be sure, for example, we have a complete record, including what certain persons' intentions really are?
I cannot think of prejudice to the county.
Okay, thank you very much, Mr. Hopper. I always appreciate the information you provide us. Thank you, Mr. Chair. No further questions.
Thank you, Commissioner Okuda. Commissioner Ohigashi, followed by Commissioner Giovanni.
Where are you there? I'm looking for you. Mr. Harper, I found you. Mr. Harper, I'm going to ask you the same questions that I was asking Randall Sakamoto about. And it refers to your filing on December 1st. I'm assuming that since that certain statements in there haven't changed, and I'm referring to page 4 on the bottom paragraph, if you have it, and it talks about decision, the decision and order which states under, I think, finding of fact 85, and this is what it says: that the petitioner proposed to develop and dedicate approximately 110 acres of parks and open space, as well as the community center within the Wailuku Project District. And then, yes, on the next page, it talks about the binding obligation that became a binding obligation to condition number 10 on page 50. And that's the position of the county, I understand, that the condition number 10 binds these representations made.
Yes, that a community center was required. Yes, the county has taken the position that a community center is required. Correct.
In addition, what would you say about the 110 acres?
I'm sorry, Commissioner, let me break in here for a minute. I didn't get the last answer by Mr. Hopper. I cannot hear him.
What's the language of the DNO and the condition? This is this the same as the conversation about housing or affordable housing? Is that what he's asking?
I'm sorry, I'm sorry, the reporter needed me to restate the answer?
Yes.
Oh, yes, the community center, I stated that the community center was a representation made, and we believe that that was an obligation.
And would that apply also to the 110 acres?
That we have there's a parks condition about that. It's a bit more specific, but the county has been in discussions with the Parks Department on this issue and believes that there are outstanding compliance issues there. But that's something at this point we flagged as an outstanding compliance issue that will need to be addressed, we believe, in the Kehalani docket with Kehalani, but that's an outstanding compliance issue. Whether it's specific to 100 acres, I want to confer with the Parks Department on that, but the community center is something that it's a bit more specific in there and that we believe is required.
Well, it seems to say both very specific, 110 and 110 acres and the community center. But going on further, you state that they will be RCFC shall petition the State Land Use Commission to determine whether the requirements of Final Fact 85 require it to construct a community center. Is that part of the stipulation that was signed by the county?
No,
it would include that.
No, this is a reference to a letter that the developer had sent to the county at some point to discuss a potential resolution. And I think the reason the county filed two things. It filed the stipulation, and then it filed this document, which is a response to Kehalani's list of outstanding obligations. Before acting on the stipulation, the county wanted the commission to be aware that it did have outstanding, I'd say, disagreements with the petitioner on what obligations still had to be fulfilled. We do believe that those could still be addressed after bifurcation in the Kehalani docket. This item is not in the decision in order, but it was a proposal by, I believe, the developer to fix the issue, that something that they may do in the future, along with other things, to address the ongoing compliance issues. But it's not currently in the as part of the decision in order.
Okay, so if the logic is condition number 10 of the DNO incorporates the findings of fact and representations made, or incorporates the representations made and enumerated in the findings of fact of the original DNO, would you say then that the requirements that the chairman has indicated regarding the amount of affordable housing is a condition of the DNO?
No, because you've got a very specific condition, condition number 1, that specifies percentages in each project district. I don't believe there's a similar thing for parks that says you don't have to give the community center. But for affordable housing, there is a condition, and commission, please, if you disagree, then please let us know. But the way we read condition number 1, it says that 30% of each project district at one income range and 30% at a different income range in each district. If we're misreading that and the finding of fact is supposed to supersede that, then please let us know. But we don't think that's a reasonable interpretation of the affordable housing issue. I think it's 30% in each district at one range and 30% at another. And then there's a lot of other language too on ways to alter that. And the county has gone back and is looking into this issue with the housing department, because this is a 30-year history and we're trying to find that. But it does appear that this condition is what controls in the case of affordable housing, because it's a very specific condition with percentages. It does not say, for example, Pi'ihana has to be 100% affordable. It says 30% at one range and 30% at another. So we went with, I believe, the condition, but if the commission has a different reading of that, please let us discuss.
I think that I err in the side of consistency in the applications of the conditions. And condition number 10 is very clear whether you apply it to condition number 85 or conditions number 20, or findings fact number 85 or conditions number 20. So my concern with the county is that knowing that they are trying to revert the property, if we bifurcate, we will lose, like the chairman has indicated, maybe 600 affordable housing units. And I'm not sure if that's the policy of the county of Maui to give up in trying to enforce to get 600 affordable units in addition to this matter. So I'm just reading your logic and agreeing with it and applying it to the various other statements within the DNO. Is the county going to file for a motion or file for a declaratory ruling on these two issues?
That's what we had planned to do, not a declaratory ruling, but that's something that would have to be done after Kehalani provides its statement of outstanding obligations. And that should be done at a either a status hearing, or if you want to do it as a declaratory order to deal with that issue. However, certainly if the commission believes that Piana has to be 100% affordable and that is tied to Kehalani's existing obligation, then that's your decision. And you can deny bifurcation and say, county, you've got to enforce against Kehalani and make them build 100% of the units in Pi'ihana. But I don't think saying after reading condition 1, I can't see that as a reasonable reading of condition 1 to say, instead of 30% one range and 30% at another, it's actually 100% affordable in Pi'ihana. That seems inconsistent. I think what was happening was that those findings of fact were discussions of what the parties had discussed. Right after those findings of fact, it says the county of Maui thought the ranges should be different because putting 100% affordable is too heavy of a distribution. And then HHFDC stated its opinion, and that's also a finding of fact. So I think that's how those findings of fact are different with respect to affordable housing versus with parks, which states it in more of a clear way that says 110 acres as well as a community center. But you know, if the commission has a different reading of that, then by all means, please provide that and so state.
Mr. Harper, I find it kind of concerning because the DNO just stands, and this is how we look at things. The DNO just stands. We're not, as Commissioner Okuda indicated, the ones who enforce it. The courts have prevented us from enforcing it. We're asking you, is it the policy of the county of Maui that, knowing that it made this representation in here, which makes sense to me, is it the policy of the county of Maui to ignore that provision and to say, well, we're not going to try and enforce it. We're not going to file a motion for default judgment. We don't believe that, we're not concerned about having an additional 600 units. And if you say that is the policy, fine, I accept it because that's your job, not ours. Our job is to listen to the arguments and try to make headway of it. The situation that you brought up and our declaratory rulings that the county has sought. In fact, I remember with the Kia school that the county has sought declaratory rulings regarding the overpass and underpass, which is still apparently going on at this point in time. So I'm asking if the county intends to bring that to light, or is it the county's position that we're going to let that 600 affordable units go?
The County of Maui has filed multiple documents stating that the Kealani Project District is currently not in compliance. There is nowhere in the conditions or in the decision and order that states that there are 600 affordable housing units that the project district still owes, that is owed here. Condition number 1 states that there should be 30%.
Mr. Hopper, the answer is yes or no. Is the county going to file a declaratory ruling or not?
Maybe. Potentially in this case, we may.
I think it's a great time for a break if that's acceptable to all parties. We've been going on an hour and 5 minutes. or hour and 6 minutes, 2:06. I'd like to recess till 2:16, and then we can let Mr. Ohigashi continue, followed by Commissioners Giovanni and Chang. Recess till 2:16. Are we having fun yet?
I don't know. You have to ask.
It was a rhetorical question, Mr. Derrickson. Okay. We have a minute more of break, but we're ready to go. Commissioner Ohigashi, did you have further?
No further questions.
Okay. Commissioner Giovanni, followed by Commissioner Chang.
Thank you, Chair. Thank you, Mr. Hopper. I always appreciate listening to you. I always learn something. And let me acknowledge up front that I think the County of Maui has had their hands full attempting to enforce the conditions of this 30-year-old decision and order on this particular property over the years. So I'm sensitive to the difficulties. Having said that, I'm reading the proposed or the executed stipulation that's part of the current immediate petition. And in particular, there are 3 requirements on the Pi'ihana project district, which come due 6 months later, and 1 condition on the Kehalani, also 6 months later. My question is, in the context of enforcement that the County of Maui currently has the authority to do, is there any reason it couldn't ask for or demand these same requirements today prior to a decision for bifurcation?
No, I believe, though, these came up in the context before any bifurcation motions. We had a status conference for the C. Brewer property for all these properties, and that's sort of the genesis of this whole thing. And so what we had wanted to ensure was that if there's a bifurcation, that this issue doesn't go by the wayside, and that I mean, we could request them, but in this case, it's the commission actually ordering them to do it. And if they don't do it in this commission's order, then there will be some consequences for that, potentially to the party. So I think we had, again, the original motion for bifurcation didn't have any of this attached to it. And the county thought that this would be a good opportunity to require this. And then it wouldn't just be the county reviewing it, but also the commission would be aware of what's going on, consistent with this sort of starting as a status hearing before the commission.
Okay. I appreciate that explanation of logic, whether or not I agree with it. I do see your logic in it. In view of the representation that was made today by Mr. McFarland on behalf of the Pi'ihana project, that in essence, that the developer does not have the wherewithal to comply with these, the financial wherewithal to comply with these requirements. And the expectation is that in 6 months, we would get an answer that says, I'm sorry, I can't do it. I don't have the money. Either that, or they would pursue some other strategy of non-compliance. Do you still think it makes sense to include these requirements as part of this stipulation?
I think so. If we want to change the wording on the financial capability statement, given that today there's been a formal statement that they're looking to revert, I suppose we could look at that. To be frank, the county did not believe that the petitioner or the landowner would be able to develop this project, which is why we wanted to proceed further with enforcement because originally in this, they said, yeah, we're looking for financing, we're doing other things, but it appeared to us that the intention was to sell off as much of the property as possible and which normally you don't do without a subdivision. But based on that concern, we believe that, yes, that could still be addressed after bifurcation as it would relate to enforcement on the Pihana side. With this, you would at least get an answer that we are unable, and something on the record, which we don't have other than the statement today by Mr. McFarland, something on record that states we cannot complete the project, which would provide a basis for further action. So maybe we could change the phrasing of that. I understand what you're getting at is why bother with this if they're saying we're not going to go forward with it. But the thought was to bifurcate, pursue enforcement on each side individually with respect to their obligations, and we could proceed with finding the financial condition and appropriate enforcement after that. What part of the concern may be is that if they provide it now, or they make the statement now, and they state we cannot develop it, does that change your position with respect to bifurcation? And with respect to the county, I don't think it did, but if it changes the commission's position, then that's something we would need to discuss. But I understand your questions on that and your concern with respect to leaving it in there. However, I think it would be a good opportunity to get a formal answer that says we cannot develop it and have that on record. But there's probably, I don't want our goal, I don't want to try to argue with the commission on things. I think our goal should hopefully be to find the best way forward with this docket that has become very problematic. So if there's a preference to either defer or to change this language, then I think we would pursue that. But I think this was the county's best attempt at finding a way to both approve bifurcation, which we think is appropriate, while not ignoring the ongoing enforcement issues.
Okay, thank you. My final question relates to a exchange between Commissioner Chang and Mr. Sakamoto regarding whether or not it would be arguable if there were still joint responsibilities of both developers for conditions that apply solely on the property that is known as the Pihana. Would you agree or disagree that there's an argument to be made, or that would you take the position that if bifurcation goes forward, there's no recourse whatsoever for holding the developer of Kihana, let me get that correct, Kehalani responsible for any of the conditions that might be judged to apply to the Pihana property?
Yes, I would agree after bifurcation, based on the decision in order, only the conditions and representations that are stated in that order that apply to Kehalani will apply to them. So to the extent that they would apply to Pihana, the Kehalani developers and the homeowners in Kehalani would no longer be responsible for effectuating development in Pihana. That's correct.
And if we do not bifurcate, the opposite would be true?
I think, yes, technically the decision order would apply with both, but we have raised our concerns with attempting to enforce a DNO, attempting to require Kehalani, even if the DNO is still as it is now, requiring them to build housing on land that it doesn't own anymore. That was a legal concern that we had, even though I think, as you stated it correctly, until bifurcation, the decision in order is how it is right now.
That's what Commissioner Chang referred to as the so-called argument, I believe. So thank you, Mr. Hopper, and thank you, Commissioner Chang. That's all I have.
Thank you very much, Commissioner Giovanni. Commissioner Chang, so patient, thank you.
No, thank you very much. Mr. Hopper, you've always been extremely helpful in helping to clarify. I'm going to share with you what my angst is with this case, as well as with many others that come before not only LUC, but other government agencies. It is going back to the original intent of the DNO that was approved 30 years ago. Because of failure to timely implement those conditions and the development when they were required to, we are now faced with these current situations. And this is not only LUC, and it's not only just the County of Maui, but I'm really struggling with this as a member of the public as well. When this DBA was made, there was no indication that these were going to be separate developments. This was treated as one development. All of these conditions ran with the one development. Subsequently, the properties were sold and the development structure changed. Yes, so the arguments that the parties make today about the validity and the appropriateness of the bifurcation, it is the present situation. But what got us here 30 years ago was joint and several responsibility to do all of these conditions. Now we are being asked to take away the one leverage that we have, which is obviously Kehalani has got access to more resources. They've than Pi'ilani, Pi'ihana. And in all due respect to the Kehalani, you know, the landowners there and the desire by those petitioners to get some clarity. In my view, lack of clarity is in the best interest of the public. If we can hold both parties responsible for some of these, these obligations that were required, why shouldn't we do that? Why should we give up the original intent of this DNO? And we should not be rewarding parties who, disregard these conditions, build when they're not supposed to, sell when they're not supposed to, make representations when they're not supposed to. I apologize if, you're asking, okay, so where's the question in all of this? So I guess that my question to the county is, you say it is, we need to take action against the appropriate parties. So the enforcement on Pihana, we should hold those people responsible. But at this point in time, in the absence of the bifurcation, don't we have greater leverage to ensure that these obligations get fulfilled if we keep all the parties into this action, into this particular docket?
I brought this up a few times. I'm not certain if we can bring enforcement action against the Kehalani owners and successfully require them to build housing on properties they don't own. I guess we could issue, and I don't want to get into potential litigation scenarios against the Kehalani owners, but I understand that legally under the DNO that all land that's owned is encumbered by the same DNO, and therefore technically someone in Kehalani, whether they be homeowner or developer, is responsible for fulfilling the Pi'ihana project conditions like the Imekala Drive extension, which is the bridge, and other things. I am just concerned being before, well, I don't want to get into specific litigation scenarios, but sure. I think I did already mention before to try to require an owner to build housing on property it doesn't own anymore for development that it doesn't have an ownership interest in anymore. I'm not sure how different that is than somebody sells their property and well, it's different. It's different than someone just selling the property because the DNO is still recorded on the Kehalani lot. But my concern is with the impossibility of performance potentially if they don't own the land. But I agree with you there that there's joint obligations currently under the DNO, but with how the property is owned, and I would note in the DNO how it's described, because in multiple areas it refers to Pi'ihana Project District requirements and Wailuku Project District requirements, how that will be read if we pursue enforcement against Kehalani owners for development of Pi'ihana. So I understand what you're saying as far as the leverage concept, but I do have legal concerns with that enforcement mechanism.
But that legal fiction has been created as a result of the party's independent action to treat these as two separate districts. Under the original DNO, they were one. That is not, the Land Use Commission is not part of that. The Land Use Commission wants to ensure that the conditions we made are enforced. And aren't we rewarding parties or people who purchase properties knowing what the conditions are? Aren't we rewarding them by saying, oh, we're not going to take any action because you don't, we can't enforce? I mean, government has too long, we made promises to this community. Certain conditions were probably negotiated in order to get this DBA. We are totally disregarding that original intent by going with the current circumstances. And it does, at some point in time, one has to say enough is enough. We need to stick to what the original intention is. If that means we need to litigate that and someone tells us we're wrong, but in the absence of that, we are constantly being asked to compromise because the conditions have changed. However, we have heard from enough people in the community that they're going back to the original conditions. And isn't that our obligation, not only as LUC, but as the county as well?
Again, several points. One, if we could prevent somebody from selling off a portion of a project, yes, that would be great. It would make it a lot easier. There are McKenna Resort, I think, as an example, that's been sold to different owners and is in fact contiguous. So that's an even bigger issue than we have here. But we cannot do that at this point. Parties or landowners are allowed to sell their property to whomever they would like, apparently. And we don't have a legal recourse there. The decision in order, when we read through it, clearly does contemplate two different project districts. It in fact describes them as two separate non-contiguous parcels, which I believe is unusual for an LUC docket. Usually it's not two separate parcels in one docket. It's described as the Pi'ihana Project District and the Wailuku Project District. And in many cases, there are separate, for example, traffic described in the separate project districts. So I do think that. The other issue is what obligations are being lost by the bifurcation? And that's a big question the county had asked, was that are there obligations that don't have to be fulfilled if the property is owned, is bifurcated. And with the allocation of conditions, that was the intention, was to have the parties be responsible for the same obligations that they were under. If by having conditions not fulfilled, you're talking about the current Kehalani owners not building out the Pi'ihana Project District, I suppose that is something that they won't have to do anymore. But currently, after selling it, just like if a landowner sells their entire interest in a project, can we sue that landowner who has already sold and doesn't own the project anymore to perform on the project that they've already sold? I think the future property owner may be able to sue them, but I don't think the government has recourse there because it's the new owner that has that responsibility. So I don't think we saw that as a reduction in the infrastructure and other conditions that were required by bifurcating. So I think that was the county's perspective there. As far as the project district, this was certainly a unique DBA because it involved non-contiguous parcels that were a fair distance apart from each other and that are described in the DNO as separate project districts. And in hindsight, yes, I think it probably would have been more appropriate to do a DBA for each separate property with their own separate conditions, because I don't think there was a lot in here. There wasn't like a situation where you're supposed to jointly develop a traffic improvements. The traffic improvements were separated out by project district in there. And so I don't think the intention was to say that the master developer is going to build out a certain highway that's going to service both projects necessarily. I think they were separated. So it's an unusual docket in that sense. And when we reviewed it, we saw that. But that's, I think, our response to the question that you had.
And I appreciate that. I guess when I look at this, I think what was the same was the landowner. The fact that they're non-contiguous, but I believe that BREWER owned both of the parcels and wanted to develop both of the parcels, probably for different purposes. But again, and I'm sure, I'm not going to belabor this, but my concern is, again, is that we are being asked to rewrite the original conditions based upon current circumstances, when the current circumstances are the result of the party's own doing, not anything with the community or with the LUC. So it does really trouble me that we are not fulfilling the original obligations that we made when this DBA was made. So I understand your position, the county's position, but I won't say anything more. So thank you very much.
Thank you, Commissioner Chang. Commissioner Giovanni.
Mr. Hopper, we heard testimony from Mr. Sakamoto that there are two RCFCs. There's RCFC Kehalani LLC and RCFC Pihihana LLC, both of which acquired the land through some form of foreclosure mechanism. They required ownership. But Mr. Sakamoto could only speculate as to the owners of interest in each of those LLC, and he said that there's probably some common owners. Does the county know who those owners or who the parties of interest are in those two LLCs?
We don't know of the detailed corporate breakdown or the ownership structure of those LLCs at this point. Or I don't know offhand.
Thank you.
Commissioner, thank you. Commissioner Cabral, had you raised your hand earlier, your physical hand?
No, but I think I'd like to hear what OP says, because we've heard so many things. I'd like to hear what they have to say, and then I have some action we might want to take.
Okay. We're still on questioning of the county. I have a couple of questions for Mr. Hopper. If no other commissioners have questions. Mr. Hopper, I share.
Excuse me, Chair. I'm sorry, Jean here, court reporter. I'm going to ask again. Mr. Hopper, please raise your voice. I'm having great difficulty hearing you. Thank you.
Mr. Hopper, I join in my colleagues with always, it's a pleasure to hear from you, and I listen keenly to your responses. Tell me if I've heard you correctly. At the core of the county's interpretation of conditions 1 and 10 is a belief that it would be impractical, if not possibly undoable, to require one landowner to build affordable housing on another landowner's property. Have I heard you correctly?
I'm saying as a legal matter, if I was in a court arguing that, that would be potentially a difficult position to try to take. I'm not sure.
So let me ask you, does condition 1 specify that the physical building of units on those properties is the only way to fulfill those conditions?
No, there's other ways.
So that's why I'm confused at your stance. That's one of the two reasons I'm confused at your stance. And following up on Commissioner Ohigashi's questioning of you, I am concerned that we interpret dockets and decision and orders consistently throughout. It's not that we haven't come across dockets from 20 or 30 years ago that have some inconsistencies in them, but we try at least to apply these conditions, the same logic to reading all these conditions. And when I read condition 1, I guess I want you to walk me through the county's understanding of condition 1, because it says in terms of tallying up, in my reading, the number of units required, the number of units required for the entire docket is 30% of the units allocated to the Wailuku Project District and 30% of the units allocated to the Pi'ihana Project District. But it goes on to say, but you can build these in any distribution between the two areas that you want, or in any other part of the community plan area, or there's frankly a part of the condition I don't understand about producing units at a higher affordability rate and getting certain credits. So I'm not understanding how that is necessarily inconsistent with the other representations when it says at least 30% of the units in that area will be affordable. 100% is at least 30. It's consistent. I'm not understanding the county's interpretation.
Yes, so if you would go back to the findings of fact, this is what we read for them to state. And gosh, I don't want to keep this here longer than we have to be, but
nor do I, Counselor.
But you know, finding of fact 24, you had referenced. So number 23 talks about 100% affordable in the Pi'ihana and 37%. And then it goes on to state the basis for that. And then it does say number 25, based upon socioeconomic concerns, Maui County proposes that petitioners' housing allocation be distributed to provide 60 more affordable housing units in the Wailuku Project District and 60 less in the Pi'ihana District.
Yeah.
And then it says state HHFDC expressed concern regarding the petition's proposed high concentration of affordable housing in the Pi'ihana Project District and propose that the affordable housing units be equally distributed between the project districts, and then goes on. And then, as you said, they will continue working to resolve the differences. And then you have, after that, which I believe was a statement of what went on at the hearing and what was on record at the hearing, condition number 1. And condition number 1, I believe, states that the requirements are, I think it amounts to 60% in each district, 30% at one rate and 30% at the other. And then it also states that credits can be provided to fulfill this requirement from housing, and that the condition may be fulfilled through construction and distribution of units in the property or through other projects within the same community plan district as the property under such terms as may be mutually agreeable. But it does appear that the minimum is going to be 60% in each of the districts at certain rates. Now, I believe that the commission had intended to say Pi'ihana at a minimum had to be 100% affordable. As part of that condition, it would say this Pi'ihana has to be 100% affordable rather than 60%. So I think that was our reading of the condition. And that after hearing from all the parties' arguments, which were set forth in the findings of fact, the commission settled on this condition. And so I think that's how the county read that condition.
But it's a complex set of issues, but I guess what I'm getting at is, I don't think there's any reasonable way to read this decision in order to think that there were no affordable housing units expected in the Pi'ihana Project District. Is that correct?
Yes, it does state, though, insofar as possible, the petitioner shall implement this affordable housing requirement concurrently with the completion of market price units for the residential project. So I think that the percentage means it kicks in when you build the housing. So if you built market rate housing in Pi'ihana, you'd have to build the affordable. And
well, no, that
sorry.
I don't think that the condition supports that interpretation, because rather in the findings of fact above, one of the ones that we referred to earlier, it talked about the developer seeking the allocation of affordability to a 100% of Pi'ihana later because of the basically increased infrastructure costs for developing Pi'ihana versus the Wailuku Project District. But that didn't actually respond to my question, which was, there's affordable housing that's going to be required in Pi'ihana, and that it was really part of the overall allocation of affordable housing in the entire project. Is that not the county's interpretation?
I think it says 60% of what is built in Pi'ihana has to be affordable. I don't believe. if you read-
It says 30%, a number of units equal to in each district. It doesn't say physically built there. And in fact, it goes on to say, and sorry to berate this and draw this long day out further, but it goes on to say, and you can develop these in either area.
And outside.
Yeah, it's 30%. So 30% of what's built. I mean, if you're saying that, I think we're not seeing this the same way. If you're saying that, for example, Kehalani couldn't build any market rate units until it built units in Pi'ihana, so that Kehalani.
I'm not talking about sequencing.
Yeah, so I mean, at this point, I think the county's position would be that 60% of the units in Pi'ihana, when they're built, are required to meet these affordable income ranges, 30% at one and 30% at the other. If they are never built, though, then you've got issues of substantial commencement, certainly, but until it's, what is it? It's
But
30%.
substantial commencement applies to us, not to you.
Yeah, certainly. But I mean, if there's no percentage upon which to base anything, if the district doesn't have any units built yet, would be the issue we would be looking at. 60% of what would be the question?
I don't have anything further at this point. Anything more for Mr. Hopper, commissioners? My final response is, Mr. Hopper, I hear what you're saying, but I don't think that you can look at the entirety of the docket and come to that conclusion reasonably, is my reading of it. But I respect that you have read it differently. Office of Planning, Ms. Apuna, who has waited oh so patiently.
So the Office of Planning did sign the stipulation and was supportive of the bifurcation, but with the new information that was provided by Mr. McFarland today, we can't in good conscience continue to support the stipulation. I think we would like some time, not a lot of time, to review it in light of that information and to understand how that works. And I think that's basically what our position today.
Okay. Questions for Ms. Apuna from the commissioners? Commissioner Cabral.
Yes, I'd like to defer to Commissioner Arnold Wong, please.
Okay, we're not yet in deliberation. If you're, I know you're trying to move us to deliberation, I believe, Commissioner Cabral.
Yes, well,
desperately. I just want to make sure that there is an opportunity for anybody else to ask questions of Ms. Apuna, or if there's any final bites at the apple of asking questions to any of the parties.
Okay, I'll try and wait a little bit. Thank you.
Commissioner Okuda. Commissioner Okuda, you're muted.
Here we go. Sorry, using a different computer today. Ms. Apuna, if since you represent the Office of Planning, which is also the keeper of public policy, maybe I can ask you to comment on the observation Commissioner Chang was making. And I don't mean to put words into her mouth, so let me just take the words out of my mouth. That it really seems like we come across these dockets where the easy money is made by the developer, and the stuff that's not easy money, oftentimes the affordable housing, it's just left undone. And what's left undone are other infrastructure promises. And then when 25, 30 years pass, people come and petition us and say, well, change circumstances. A lot of time has gone past. relieve us of these obligations. I mean, isn't there a public policy reason why the Land Use Commission really should start taking a harder line in these cases and really make the point that, yeah, I guess somebody's going to suffer at this point, the successor in interest maybe to the original petitioner. But you know what? Promises made to the community have to be kept. That's one of the reasons why people don't trust us in government anymore, because we say things when we're in government positions, and either deliberately or just by the passage of time, we don't live up to what we say. And so you really can't blame the community for saying, why should we listen to you? Why should we trust you folks in government? Because in the end, what you say is worse than just a shibai. I mean, you have any comment to that, since Office of Planning really is the custodian of the public trust?
Thank you, Commissioner. I think that OP understands and the frustration that the commission feels on behalf of the community and just on behalf of whatever conditions are made in the original decision and order. I think we also understand what Mr. Hopper is saying as far as the legal ability to force or, require these developers at this point to hold these conditions, make sure that they build the housing, affordable housing. I would offer maybe that what the commission can do is with any new DBAs that there are more stringent timelines and requirements of the developers to make sure that they are doing these things timely, within 10 years. Or I think Commissioner Chang mentioned, bond requirements, that there might be other ways to really require the original developer to perform as represented. But yeah, it's a difficult position at this point, because if Mr. McFarland says that his client can't do it, I don't know how we can force him to do what he is required to do at this point.
Okay, thank you very much, Ms. Apuna. Thank you, Mr. Chair. Nothing further.
Thank you. Commissioners, is there anything further for Ms. Apuna? If there's nothing further for Ms. Apuna, I'm going to ask, is there any further questions of any of the parties? It is 2:53 p.m. I will note that we have gone on obviously very long. So if the questioning might be brief, any follow-ups? Any questions, commissioners, of Mr. McFarland, Mr. Sakamoto, Mr. Hopper, or Ms. Apuna? I'm going to allow a brief period for any of the parties to add anything that they might wish to add, starting with Mr. McFarland.
I don't have anything to add. I appreciate all your input. I do respect your input. I think you guys are trying to arrive at the right decision in a complicated situation, and I'll just leave it at that. And have a happy New Year's. Thank you very much.
Thank you, Mr. McFarland. Mr. Sakamoto.
I have nothing to add, Chair. Thank you.
Thank you. Mr. Hopper.
Only that, just to be clear, the county is not taking the position that the conditions are unenforceable against the parties to whom the obligation is owed at this point. We have in fact filed a document stating the instances where we believe there are compliance issues with some of the Kealani conditions, and still believe that needs to be pursued. Kealani is not fully built out yet, so there are still obligations that have to be fulfilled, and we believe that they can be done in this docket. But we didn't want to create the impression that we believe, oh, the conditions are now unenforceable, let everybody go. That's not the county's position. It's that that after bifurcation, we believe the conditions will still have to be enforceable against the parties that own the land that they own right now. So I just wanted to have that clarified.
Thank you, Mr. Hopper, for your further clarification. Ms. Apuna, you just spoke, but did you have anything further?
Nothing further, Chair.
Okay. So then, commissioners, we are now in deliberation and we can entertain, we have before us a motion from Wailuku Plantation LLC's a motion to, for an order to bifurcate docket number A89-642. We can either approve, deny, defer.
Chair, this is Commissioner Wong.
Commissioner Wong.
Yeah, Chair, you know, in light of today's discussions and very lengthy discussions and information that was presented to us, it is my opinion that this matter is not ripe for a determination. I would therefore move that we reject the proposed decision in order and stipulation and direct the parties to continue discussions on this matter and not to return to the commission until evidence of the following. One, financial capability is filed with the commission. Two, the responsibility for various conditions and requirements is resolved and given the information received at this hearing. That's it.
Second.
Oh, too slow, Nancy. You can third the motion.
Third. Okay.
A motion has been made, just to clarify, I'm restating, to reject the motion and to direct the parties to not come back to us with another stipulated motion until there's been the verification of financial ability, which was, I believe, Commissioner Wong, you're referring to the language that was in the existing stipulation but was postponed for 6 months. You want to see that done before?
Yes, before they come back to us.
Okay. And then the second part of your motion was clarification on the assignment of responsibilities of all conditions.
Correct, and the requirements, given the information received at today's hearings for the affordable housing and everything else that's involved, community center.
Okay. Folks, we have a motion before us. I'll allow the movant, the seconder, and then the third to speak to it.
So, Chair, the reason I made this motion is because there's still a lot of questions I have. One, the information about the affordable housing, those conditions. The public brought about the community center, who's going to build that? Chair Giovanni, Commissioner Giovanni, sorry, Chair.
Are you trying to tell me something?
Little tired, but about the bridge and, you know, who's going to pay for that? What is the breakdown? Who has the money to pay for these things for the community? So those are some issues that I'm really.
Hold on. You were muted you were muted by your executive officer.
No problem. Yeah. No one wants to hear me again, and not even my wife, but.
So if you, court reporter, where did you leave off?
Give me a second to try to find it, Chair. I'm looking. Talking about the bridge, who has the breakdown, who has the money to pay for these things for the community. So those are some of the conditions that I'm really, and that's where it stopped.
So it's, yeah, I'm concerned about all these issues that was in the original DNO. So that's why I made that motion, Chair. That's it.
Thank you. Commissioner Ohigashi.
Happy New Year. The reason why I'm supporting this motion is essentially because it appears that Office of Planning has requested that they are not going forward with the stipulation. Absent a complete stipulation, there is nothing that we can do before the commission. The second thing I want to say is this, is that the Land Use Commission, with all of its decision-making powers, is limited. We're not out there with our limited staff, no access to any kind of enforcement officers, no policemen running around, that we are able to enforce conditions in our P&O, especially when we do not have the substantial completion or compliance with the DNO. That being said, the statute limits that authority and discretion to the counties. And in this case, I am hoping that the county would take a look at its policy and heed, I think, what Mayor Victorino indicated at his the start of his administration, that housing would be the number one, affordable housing would be the number one policy of the county. And rather than explain to us why they cannot do it, perhaps they should take a look at how it can be done. Famous former mayor that I was a deputy at Corporation Council was Hannibal Tavares. And I kept telling him, oh, you can't do this, you can't do that. And he once told me, Lee, tell me not that you can't do it. Tell me how I can do it. So I think that that message is important to our lawyers. Is that tell us how we can make sure that these things are enforced, how we can get the additional housing for our people, rather than telling me how I cannot do anything. Thank you.
Thank you, Commissioner Ohigashi. Commissioner Cabral.
Thank you for letting me be number 3. And before I forget, yes, absolutely. Happy New Year. I'm so ready to have this past year gone.
I remind the commissioners we have one further agenda item after this.
Oh, yes. Okay. But I do want to comment on this, that I am wanting to defer because I think we clearly have more unanswered questions and we have so much unclarity among even those testifying and presenting their opinions to us, that we really need to get more clarification as to what's what. This is such a complicated issue because of the fact that 30 years ago, I would say that it was done wrong. And we now have, 30-30 hindsight or something. But so I wanted to comment on hopefully us as the commissioners now today really make certain we are very clear in our current and future decisions, that we don't provide confusion in the future to some future commissioner, because I think that's, in a perfect world, this would have already been developed, built out. There'd be all the affordable housing, the bridge, everything would be done and no big problem. But I think we all need to do a better job doing our job. And then I would make a comment, because I do housing and I do administer affordable housing on the Big Island, that there is both for attorneys, McFarland and Sakamoto, tell your clients they need to figure this housing out, because there is a lot of affordable housing money coming down from federal areas, as well as different agencies who have got a lot of money floating around. And if you provide the land and maybe at least the stub outs for the sewer line, somebody else will build it. So they need to be a little bit more hardworking in trying to make that happen, because I do know that the money's there. Thank you very much.
Thank you. Commissioners, we are in deliberation. Does anybody else wish to speak to the motion before us? Commissioner Giovanni.
Thank you, Chair. I'm in favor of the motion that's been second and thirded. I share Commissioner Chang's angst about 30-year-old decisions and orders that are never implemented as originally represented to the Land Use Commission. And this particular docket is not unique. I can count back within the last 6 months 2 other similar situations where, as Commissioner Okuda represented, you go for the easy money first, the developer does. And too often they come back with a request or a petition to relieve them of conditions that are not profitable to them due to changing circumstances 20 and 30 years later. This is not what the community expects. It's not what the Land Use Commission should expect. And I'm also sensitive to and in agreement with Ms. Apuna's suggestion that on a going forward basis, and I think this is consistent with what Commissioner Cabral is talking about, that when we do put conditions like that for infrastructure, or for roads, or for affordable housing, we put them on timelines that make it very clear that they can be enforced relative to a timeline and make it easier on the counties to do that. So in this particular docket, I am in favor of the motion and I will vote in support of it. Thank you.
Commissioner Chang.
Thank you, Mr. Chair. And now I apologize if I have, I'm not writing any kind of a soapbox, but I think I am at the point where enough is enough, where we really need to hold people's developers to their commitments, because those are the basis upon which these approvals have been made. So I think moving forward, I agree, we do need to be much more specific. I am going to look into whether we can require a bond be held in escrow to ensure that infrastructure is developed or affordable housing. But I think we need to there needs to be a disincentive to buy and sell, go into foreclosure, and then our communities are holding the bag with a park that has a gate that they cannot even enter. Or, or we've got conditions about foregoing the affordable housing, and we're now coming in, they wanted to build more market homes. I think we need to start looking out for the public's interest. So again, that's all I have to say. I have greatly appreciated all of the parties' openness and bringing this to our attention. So thank you very much. That's it.
Thank you. Commissioner Okuda.
Thank you, Mr. Chair. I will also be voting in favor of this motion. I agree with everything that has been said up to now by the other commissioners, and indulge me to repeat myself. I think it is very important that government lives up to what government represents and states is going to be what is going to take place. And if things are going to change, and I think I said this at the Waimanalo Gulch landfill case, another case where the record indicates that representations to a community were not kept. But if things are going to change, then it's incumbent on the people who want the change to go out to the community, demonstrate with admissible evidence the reasonableness and the need for the change, and get the community to support what the change is. I mean, we on the commission, as you can tell, we will listen to all the evidence. We'll listen to all the evidence. We'll give people the time to present the evidence. But when requests for changes are being made on representations which are embodied in what amounts to an enforceable order, and the community testimony is one that indicates serious questions of trust by the community, I mean, a reasonable petitioner or applicant would see that's going to be a problem. So going forward, I would really urge the parties to talk to the members of the community, get them on board, or at least make it very clear so that they might have disagreements if they do, but it's not going to be like somebody is trying to basically change the ground rules after the fact. And again, because if anything we all got to seek and try to do is restore trust in our government. And we can only do that if we all live up to the representations we make. Thank you, Chair.
Thank you, Commissioner Okuda. Is there anything further, commissioners, All I will do is echo the eloquent statements of my fellow commissioners. I join in them. Mr. Ordenker, would you please poll the commission?
Sorry, Mr. Chair, I'm still laughing over Arnold's response to your statement of eloquence. To reject the proposed motion and stipulation and direct the parties to continue discussions and not return until they have verification of financial capability and clarify responsibilities on all conditions and the requirements contained in those conditions. Commissioner Wong.
Aye.
Commissioner Ohigashi.
Aye.
Commissioner Cabral.
Yes.
Commissioner Okuda.
Yes.
Commissioner Giovanni.
Aye.
Commissioner Chang.
Aye.
Commissioner Axon is absent. Chair Schreier.
Aye.
Thank you, Mr. Chair. The motion passes unanimously with 7 votes.
Okay. Thank you sincerely to all the parties. Grateful for your endurance on this matter. Commissioners, I think this next matter could be brief and we could perhaps not take a break, but just go through it. I'd like to move to the next agenda item, which is legislative matters impacting the LUC. Mr. Hakoda or Mr. Jackson, has anybody signed up to testify on this matter?
Mr. Chair, this is Riley. No testifiers.
Is there anybody who's listening in the audience who wishes to testify on this particular agenda item, legislative matters impacting the LUC? Seeing none. Mr. Ordenker, can you please brief the commission?
Thank you, Mr. Chair. There are a number of matters that the commissioners have expressed concern about that revolve around the legislature this year. One of them was, of course, the proposed furloughs that are now postponed until July. Furloughs would have had a significant impact on LUC operations. Any decrease, as everyone knows, we're so small that any decrease, percentage decrease in time spent in the office and time working has an exponential impact on our ability to move matters to hearing and to complete the work and preparation necessary for hearing, as well as decisions and orders subsequent. Of more concern, immediate concern, is various restrictions. We were gifted in being able to hire Natasha. However, we have 2 vacant positions are not going to be allowed to fill because of both the governor and the legislature's restrictions on personnel, hiring and firing and personnel, hiring of personnel. Legislatively, the governor's budget has been submitted, and it was, I would caution that it was done prior to the latest relief package, so there may be some changes. However, the governor's budget has a 50% reduction in our travel expenses next year and 100% reduction in the subsequent year. Why it's not the other way around, I don't know. I can't answer that question. But that's what's been submitted. I'm not sure how that is going to play out and what changes will be made as the legislature continues. We have not seen any specific legislation as yet with regard to changes to the LUC, eliminating the LUC, or any other measures impacting the LUC other than the Office of Information Practices proposal that would allow amendments to Chapter 91 and 92 so we could continue to do Zoom meetings. However, we have been informed, and we are still in discussion with various committee chairs regarding this, what is being termed a streamlining of government and the combining of various organizations with synergistic programs. At the moment, we don't know how that is going to play out, but it is not inconceivable that there is a proposal put forward that somehow combines the LUC with various other land use activities in the state system. But once again, I would caution that we're still in discussion with regard to those, and we don't know exactly what that's going to look like. I can answer any questions if the commissioners have any.
Commissioners. Discussion. Question, Commissioner Ohigashi.
I just have a question. Are we contemplating trying to expand some of these deadlines that we have on the various dockets that we need to resolve because of the pandemic and the limited time we have on Zoom webinar?
We're not looking at that right now. The governor's emergency proclamation waives all of those deadlines.
So the question, does the fact that we're not able to hire additional people, that affect these timelines that we're?
It may. I don't know how to answer that question until we're actually confronted with it.
You just have to rescind Bert's retirement. No.
Tried. I tried. I was rejected soundly, but I tried. We're balancing on the razor's edge with that, because if we ask for additional time to complete work and our proposed legislation to do that, the backlash may be that we're now moving too slowly for the crisis and the needs of the development community. So I think that my feeling is that we're better off leaving that alone for now and attempting to manage it through creative calendaring.
Commissioner Giovanni.
Thank you, Chair. Dan, any updates on confirmation or reconfirmation of the commissioner's appointments to the commission? I think my term is up. I was filling somebody else's.
Yeah, I received an email during the course of this hearing saying that there are 3 commissioners who need to reapply for their positions. And I sent emails to those 3 commissioners, which I believe you're one of. So all you have to do is redo the application.
Do I have standing between January 1st and whenever it gets officially approved?
Yes, yes. The law states that after your term expires, you can hold over for 2 years, up to 2 years. So there's no concern with that.
Okay. That was my issue. Thank you.
Commissioners. Anything further? If not, Mr. Ordenker, I understand on our next agenda, you will put another legislative update. Did I understand you to say that at the beginning of our meeting so long ago?
I don't suggest doing that at the next meeting, which is only a week or so away. I would suggest doing that at the meeting at the end of January.
Okay. Commissioner Cabral.
Yeah, I do want to say, as somebody from the outer islands, while I love not living on an airplane, I absolutely really, and I think these Zoom meetings have been incredibly well done by staff, and we've really worked through a lot of the glitches that I experience on other Zoom meetings. But I think there's a whole lot to be said for meetings in person. And so I can see that the travel budget is limited to disappearing, obviously. But I think that it might be something that I would appreciate it. I mean, I might be even willing to spend my own money to travel. I mean, I have a place in Honolulu I can stay in. But anyway, because there are sometimes some topics, some hearings that I really would prefer I was in person with at least my fellow commissioners or something, because I think I get a lot more out of it. And maybe it's partly because I'm such a visual person. You know, I can remember these hearings when we had them in person with someone like Mr. Lindsay, when we were together with him in Maui a year plus ago or something. But, you know, the one on September 9th, I can vaguely remember. So it's just like, I mean, there's a lot to be said for in person, the old fashioned way. I can understand the financial difficulties here. So it might be something that we could try and work up to be an optional. Obviously Arnold's there, and I guess we could all join him on the table, and I'll bring the coffee or something. But I just want to kind of make sure we have that ability to come in person. Especially if the staff felt like the complications on a new topic or repeating topic would better allow us to do a better job.
Thank you, Commissioner Cabral. It's our belief that in-person hearings have advantages. I mean, we've been working with Zoom, but I think that there is a real benefit to appearing on neighbor islands, especially to let the community know that we're there, we're concerned, this is their island, and we don't want to make a decision from Honolulu and dictate it down on top of you. So I would agree with you. The trick is going to be preserving some kind of budget. My understanding is that almost all of the commissions, boards and commissions had their budgets cut in a similar manner. So.
Thank you. Is there anything? Oh, Commissioner Giovanni.
Yeah, I want to echo what Commissioner Cabral just said. I think that the LUC administrative executive team has done an incredible job and set a very high bar for Zoom meetings. I've tried to emulate that in other Zoom meetings, and it's just not possible. And so kudos to the team for that. And we've got some important work done as a result of that. Having said that, I miss seeing you guys. And I would love to have you here on island for the Hokua Place matter that's coming before us. A lot of local interest in that, and you know, just seeing everybody by Zoom, the community misses that. So, and finally, just hope everybody has a happy new year, and see you in 2021.
Yeah.
Happy New Year to all. Thank you so much once again for everything you've done for the past year.
Congratulations to surviving today's meeting and 2020.
Yes, thank you all.
Happy New Year from a neighbor island. There's no outer island, by the way.
Yeah. No, hey, the big island.
Is there any further business?
Chair, just wanted to say again, I know everyone echoed me, but thank you to Bert, and hopefully
thank you, Bert.
Future.
Yeah.
So that's what I wanted to say, and Happy New Year to everyone too.
Yeah, and Bert, just because you're retired doesn't mean you can't volunteer and help out now that we're short-staffed. So yeah, keep that in mind.
He can just do it for free since there's no money to pay him now.
And welcome, Natasha. Okay.
Yes, welcome, Natasha. We're really a good, nice group, aren't we?
There being no further business, I declare this meeting adjourned.
Adjourned. Mahalo.
Holy makahiki ho, everyone. Aloha.
Well,